My lord, may I have a lordship's kind leave to mention, my lord, item number 56 of my lord today's list for updation. Urgency is this, my lord. Construction is going on upon the existing roof of the basement plus ground plus historic 25 years old building. Now, my lord, 397 representation has been made to Kolkata Municipal Corporation for cancellation of building plan. As my lord, building plan was obtained fraudulently without taking any consent from my lord existing unit owners, my lord. Now, my lord, I have served all the respondents, my lord.
Sir, may I be permitted to mention
Give your slip, sir.
for release, mother, due to huge condition of your lordship's list, I am praying
No
for
release. I don't release matters.
With your lordship, kindly may be permitted to
Mention before Chief Justice.
mention item number 1804 of the
Sir,
Constitution,
mention.
my lord, for upgradation. What has happened, my lord?
Give your slip. Yes, sir.
Again, my name is not appearing in the two matters. Original size.
for release, mother,
No release, sir.
as your lordship.
Yes.
May I have my lord kindly, my lord, to mention, my lord, an extremely urgent matter in connection with the Jalpaiguri circuit bench. The bench had last sat, my lord, on Friday and is sitting next Monday. Now, my lord, there is a Planet Mall in Shiliguri which has a Manyavar and Mohe store. A proceeding for demolition was underway and commissioner had passed certain orders against which, my lord, an appeal was carried to the mayor. The appeal is pending. In the meantime, yesterday, there has been wide circulation in the local electronic media that they are going to demolish the buildings, demolish portions of the mall, including the store, tomorrow. Now, my lord, there is no circuit available, my lord, for me.
Mr. Banerjee, we will not go by the local media reports. Your matter is pending before the mayor. It is pending before. All right. We will not go by the media reports.
My lord, I have, my lord, taken screenshots. I have also, my lord, brought the
But we will not go by media reports.
My lord, there is only one other difficulty, my lord.
If you have a notice, there is an imminent threat from the department, you tell me. But media reports, newspaper reports, sorry.
They had, my lord, filed an affidavit in connection with a writ petition filed, my lord, by the complainants, where, my lord, they had said that upon 30 days of expiry of the time period of the commissioner's order, they will execute. Even that period has gotten over, my lord, day before yesterday.
That's okay. This
My
is,
lord, I am
this
today,
is
I am
no-
unprotected, my lord. I don't have a bench, my lord.
No, Mr. Ban. Monday, before the regular bench. Yes.
Permitted to mention one court
Obliged.
application, a new matter filed in the month of February, not appearing.
Give your.
Lord, then may I just make this prayer?
Yes.
May I just, with your lordship's leave, file it today to be brought before the circuit on the first day, on Monday. Otherwise, my I'll be gravely prejudiced.
So in circuit, generally matter comes up. The
Circuit,
moment,
not on the first day, if I file, the matter will come up thereafter. 48
thereafter
hours
it will come. Not 48 hours. Next day it comes. Circuit, there's hardly any filing. Not too much filing. I
Uh,
just came from the circuit, Mr. Ban.
May I just file it in course of the day so that I can at least make an attempt to tell them that I have approached court and I am before the circuit on the first available day.
Mr.
And I do
Banerjee,
this
that
one.
will be unfair on my part for the concerned bench, which is going to be there. That's not fair. You mention it, it will be listed. There, they don't have this problem. It will get listed next.
I'm obliged.
Yes.
Yesterday's. The notice is there. They are going to start day. Despite pendency of the appeal, I have served everyone. Served
Yeah.
everyone. I want to move it anytime convenient to the court, anytime. Even at 4:30, I can take a chance.
No, no,
Let me-
4:30, you can definitely take a
Whatever
chance.
time
But
suits your lordship, may it appear.
Mr. Bhattacharya, what is the urgency that you are
But they
saying?
are going to take steps, to demolish the
Where is the corporation?
corporation I have served. And he
Where is
private-
the,
he is
he is not corporation.
He is the private respondent.
I know he's the private respondent. He's not the corporation. Right?
I shall get the
But there is
corporation.
already a
No.
appeal being pending
Without
before the building
corporation-
tribunal.
There's an appeal pending before the building tribunal.
Very good. You have a stay.
Yes, we have taken steps. When I
You have-
mentioned the matter yesterday,
Mr. Bhattacharya, do you have a stay?
no, I have
Then-
taken steps to get a stay He has, the initial, my lord, adjournment was till 21st of August. It has been preponed till 22nd of July.
You are there before the building tribunal. Good for you. Try to get a stay over there.
My lord, may I?
Corporation
The
is not.
Section 5 is pending. There's a Section 5 because the building tribunal was approached after
They can
the
dispose.
court intervention.
They can dispose of your section 5 as well as your application for stay.
May I, may not, may I? I'll
Not
be
today,
completely
yeah, you-
non-suited. I'll be completely
Mr.
non-suited.
Bhattacharya, you should have ensured that the other side is here. They are also not here.
The other side is here.
Other side is not private respondent. I'm talking. Your relief is against the corporation.
I'll come at 2 o'clock when I'll get the other side.
Lord,
Get the other side.
The other side.
Lord, may I have your
No, no.
Mr. Bimal Shahi is appearing, I am told.
Whoever is appearing, as it is, he has fractured his leg or something.
No, he's there.
Anyway, you should have got him. He's not here. Mention it to. Mention it to.
Lord, may I have your lordship's kind leave to mention a matter, my lord? Lord, this matter was, my lord, heard by your lordship yesterday as item number 9. My lord, my senior argued this matter, my lord, which was withdrawn by my learned senior. Lord, at the time of withdrawing, my lord, my learned senior missed to pray before your lordship for a leave to file afresh. My lord, that part may be added,
It
my lord.
cannot be on the
And,
same cause of action
my
as
lord,
he has already submitted
added.
yesterday that they are not
my
doing
lord,
any
otherwise,
catch
my
trading
lord, my
business.
client will be, my lord,
Can't be added.
my client will suffer, my lord, immense injury, my lord. He will
Can't
be
be added,
completely
you have-
bereft of justice, my
Sorry,
lord.
sir.
My
Sorry.
lord, kindly, my
No,
lord.
sir. This is not some mistake which
My lord,
can be
that is
corrected.
inadvertent mistake,
No,
my
this is
lord.
not inadvertent at all. Sorry.
My lord,
With your lordship's
my
kind-
lord, may I come back with an application?
You do whatever you have to do.
With your lordship's
Application
kindly,
will also meet with the same fate.
Lordship, this is the
Lord,
third
as the
time
lordship-
I'm mentioning and troubling you. Actually, the matter is pending in the last 1 year.
Sir, there are matters which are pending for more than that. We will consider it whenever the appropriate time will come.
Your
All right, you
lordship,
can give your slip.
Your Lordship, just hear me out. The 4 judicial orders have been disobeyed. The respondents in nexus with the police have completed the job. The very purpose of my filing this case has been defeated. With highest respect with you, because when you were with Justice Bakshi also, the same person is doing the same thing. With due respect to you, Your Lordship, and to the judiciary, if the delay is being defeated and justice is being denied, I can be released from your court also. It is, I mean,
Sir, you give your slip.
it is
All
up,
right.
it's up to
Give
you,
your
Your Lordship. Either,
Sir, if you want, you can mention the matter before the Honorable Chief Justice. All right.
if it is released, Your Lordship.
I am not releasing. You go and mention before the Honorable Chief Justice for the matter to be released out of my board. There are matters which are pending for many years.
Your Lordship,
When this court will find it appropriate, we will allow it. All right.
Your Lordship, I had mentioned
Next.
to the Chief
with your
Justice.
lordship's
all right.
kindly, may I,
Next. Sir,
Told me to wait.
I have heard you. I have heard you. Yes,
with
next.
your lordship's kindly, may I mention item number 61 to 64 of your lordship's original side list today, where the interim order is expiring tomorrow. If your lordship kindly takes up, if the matter is not called on today, my lord, any time, my lord, I will notify the other side and come back, my lord, for extension.
Where is your slip?
But it is appearing in the list.
Maybe it will not reach.
But may I give notice and come back at 2 p.m., Lord?
Your Lordship, just interfering, Your Lordship,
should
I
have-
beg your pardon.
You should have put
Your
a.
Lordship, I am
Yes.
in this matter. I
But
had
earlier
mentioned
also
on
it was
15th,
mentioned.
Your Lordship. It
We'll
was
see if the matter comes. We'll see. We'll see if it comes. Yes,
My
Mr.
lords, leave to mention item number 59 of my lord's urgent side list, Millard. This is with regard to issuance of a distress without giving me any notice. I am a tenant of the premises. My premises has been locked by the corporation because of the dues which were not paid by the owners, landlords. Now, Millard, without any notice, Millard, Millard, so because my premises is locked and it's a commercial premises, Millard. So any precedence, whatever my lord deems fit and proper, Millard, 59 it is,
You
Millard.
don't have any goods lying there.
Millard, I have.
You have.
Yes,
Move an
Millard.
application. We'll see that.
Millard, I have filed my application, Millard.
We'll see. Next week, we'll see. You can't do it.
Millard, what I'm humbly submitting is, Millard, if it is
Give your
upgraded
slip.
in the list,
Give your slip,
next
we'll
week
see.
only, Millard, so that it is in a reachable.
Give your,
Lordship, may I be permitted
Yes,
to
ma'am.
mention, Your Lordship, almost similar circumstances.
give your slip, madam.
Lordship, I have already filed an application.
You filed an application?
already
Give your
filed an
slip.
application to this
Give your
effect.
slip.
Lordship, with the other matter, Lordship, there's another matter, Your Lordship, which is appearing as item 2277 in the monthly list, Your Lordship. What has happened, Your Lordship? I was alleging the illegal construction which is made to which affect the municipality. It's Kotrang Uttarpara municipality. They have already issued a notice that the building it's being constructed without sanction. Now, despite filing the writ petition during the pendency, Your Lordship, they have almost completed the construction, and now my path to my house is totally blocked, Your Lordship. Now, Lordship, what has happened, Lordship, as a counter, the private respondent, which is the developer, he has filed another writ petition before Your Lordship, to which the municipality is proceeding every day, knowing fully well that this writ petition is pending before Your Lordship. Lordship, may I be permitted to hand over the slip, Your Lordship? Lordship, grateful, my lord.
May I permit to mentioning item number 84, my lord, today's list, my lord.
Give your slip, madam. What has happened?
My lord, the matter is that the mother of the petitioner filed writ petitions challenge the demolition, challenge the unauthorized construction made by the private
Give your
respondent.
slip.
Lordship, may I be permitted to mention a matter item number 1281 of the monthly list? I am for the respondent number 5 in this matter. The money of my client is stuck with the Srirampur municipality. My client is the owner of the property. An order was passed on December 3, 2000.
Give your slip, 1 lakh rupees.
Huh.
Give your slip.
The Lordship, this is for the inclusion of this matter in the list. The Lordship, this is about illegal raising of demand of fees from the KMC, by the KMC on the amendment of sanction building plans. We are not getting the completion certificate. We have completed the building. So Your Lordship, kindly include the matter.
My lord, not mentioning for withdrawal, my lord.
Give the slip.
Oh, withdrawal.
My lord, may I be permitted to mention a matter which is
2015 determination.
Matter as passed by Justice Shogat Bhattacharya. Kindly look at the order there.
My lord, may I be permitted to mention a matter, my lord? It is appearing as item number 2242 of your lordship's combined list, my lord. The matter relates to demolition of illegal
Give
construction.
your slip. Give your slip.
Well, I'm paying for upgradation, my lord.
Give your slip.
My lord. No, I'm giving this.
Lordship,
Yes.
I'm appearing for the Lordship. I am for the petitioner, Lordship. Lordship, on last occasion, Lordship, KMC has filed their affidavit in opposition, Lordship. There is specific averment that the notice which is under challenge has been served upon us inadvertently on the and they don't have any claim. On the basis of their affidavit in opposition, I am been instructed to withdraw this petition. Kindly, Lordship, this is my written instruction, Lordship.
Learned counsel for the petitioner has handed over a copy of the instruction which she has received from her client for withdrawing of the present writ petition. The present writ petition is dismissed as withdrawn. Copy of the instruction is taken on record. ऊपर ही लिखते हैं, copy of the instruction taken on record.
Deeply applied.
My lord, I am appealing for the Kolkata Corporation, but my lord, this was disposed of on 26.
My lord, I am for the
June.
private respondent.
Without notice, they have.
Who's for the petitioner? He has mentioned the matter for withdrawal.
I am for the petitioner.
Yes, for withdrawal.
My lord, I have no
My
instruction.
lord, this is at the instance of the private respondent. What happened, my lord? I appeared. My lord, I argued, but my lord, our name has not entered in the order sheet. For that reason, I mentioned the matter through my learned junior.
Without notice.
Necessary correction shall be carried out in the order dated so and so. Yeah,
Without notice, না এটা তো দেওয়া উচিত।
all right.
কি কারণে হচ্ছে তুমি এখন বুঝলাম না আমার জন্য।
Private respondent.
It is only for correction of the name.
Yes, without notice. That's why. Okay, I have no problem, Lordship. Only. Get Lordship.
Lordship, Mr. Das will appear online.
Lordship, may I be permitted to appear through virtual mode? This is the application for restoration of the application, Lordship, which was taken by the petitioners for the dismissal of this writ petition on the ground of non-appearance of the on behalf of the advocate, Lordship. This was happened on 11th of December.
You are appearing from the car.
No, Lordship.
Then, where are you sitting? Your voice is not clear.
Lordship, am I audible, Lordship?
Your voice is shaky, Mr. Das.
Your Lordship, kindly make it a passover, Lordship, so that I can go to the code.
Not today.
Get Lordship.
What is there in this matter? You know the matter, madam.
No, Lordship, he will appear.
Yes, what is there in this matter?
Lordship, for the demolition of the unauthorized construction carried out by the private respondent, Lordship, that is the respondent number 5. And I made representation before the respondent authority, that is the Calcutta Municipal Corporation. They have taken this complaint, but till now no such steps has been carried out, Lordship.
You are appearing?
Well, I have been instructed to appear in this matter.
Yes.
A copy may be served upon me so that I can.
You have no objection to the restoration application?
No, madam, I have no application has been served upon me so that I.
Give an application.
An application copy.
Lordship.
There's an application. Just take down. There's an application. This is a restoration application filed by the petitioner. Full stop. Learned counsel for the respondent states that he has no objection if the said application is allowed. Full stop. For the reasons stated in the application, as well as the concession made by the counsel for the reasons stated in the application, as well as the concession made by the counsel for the respondent, the present application is allowed. Full stop. The writ petition is restored to its original position. Full stop. Can we decide the writ petition?
Not now. I have no instruction. I have not received the copy of the writ petition also. I have need.
Give him a copy of the writ petition. He doesn't have anything.
Lordship, kindly make it kindly fix the date, Lordship, so that the
writ petition is restored to its original position.
Solution.
Grateful to you, Lordship.
Grateful, Lordship.
My lord, I am for the.
Okay,
My lord, I am for the contempt.
My lord, I am for the petitioner. My lord. I am for the petitioner in this.
Your lordship is directed for filing a report. The thing remains, my lord, your lordship is orally actually directed to serve me a copy of the contempt application, because to file a report I need, my lord, whole cost title. That was sent to me, my lord, 3 or 4 days prior in a, my lord, virtue, that is the email. So, my lord, the hearing has already been.
Lordship, he himself, my lord, told me to send it either through email or through WhatsApp, my lord. I have done it. And my lord, kindly appreciate the
Contempt, my lord, I am not any allegation against the petitioner. The only thing is this: he is appearing virtually. He sent writ petition, contempt application, everything in virtual mode. And my lord, I am actually very old person, so I cannot actually find out.
You have a young person also with you.
Oh, my lord, he
can also handle.
Only 4 days.
Mr. Das.
Lordship.
My father is 88.
My lord, everybody can, my lord.
What are you saying? This is no ground, young or old.
No, my lord.
Mr. Mukherjee is sitting here. Mr. Mukherjee, can you access your mail or not?
I actually.
What kind of defense is this?
My lord, this is defense is I should send that to my department, and your lordship's direction was to file a report. What steps you have taken? My lord, that for that reason I have to actually APT one petition, And for that petition, I need some time. Only thing is this, we have already taken steps. 3 hearing has been given, 2 days appeared, 1 day they are not appearing, 3 days have been given by the special officer. Hearing is going on. We detected, we inspected the premises.
You were supposed
pass-
to finish off the hearing in 6 weeks. Everything was supposed to be done within 6 weeks. There's a direction passed by this court. You are in contempt.
That is a content, but usually, my lord, give me some more time. At least 10 days time, I will file a report, my lord, before your lordship.
You are making a mockery of this court, Mr. Das.
My lord, no, my lord, it is, I have nothing.
And don't come up with this excuse that you are old and you can't access email and you can't do that.
My lord.
And first of all, you're not old at all.
Yes.
Take down.
Lordship, may I have your Lordship's
Give
kind?
him some time. What will you do?
Lordship, may I say a few words just? My
What's the
lord,
point? They have not done it. We
Lordship,
know it.
Learned SOB, my lord, is adjourning the matter time and again without any ground, my lord. Even yesterday it was fixed, hearing was fixed, it has been adjourned, but without any ground. He is saying that yes, I am adjourning it. I am not.
Your lordship's direction was give
What
both of them the hearing.
So decide the issue.
The next date, my lord, that is within a week, we will pass an order.
You pass an order within a week.
My lord, I will pass the order.
Lordship, kindly, my lord, pass a direction, my lord, to that.
Learned counsel for the respondent seeks and is granted further time of 2 weeks to file report by way of an affidavit. Let this matter be listed after 3 weeks.
I am great.
Time for the corporation.
I
my lord.
appear for the private respondent in this case, my lord. Understand is upgraded. My learned junior says, my lord, that he has not been informed regarding the upgradation.
My lord, lordship,
Since I'm also joining, my lord, there is an obligation on me to produce the records, my lord. Since it has been upgraded without notice, my lord, I am without my
So, my lord,
records.
8 January 2025 order was passed. My lord,
mentioned
No,
it.
that
You
is
mentioned.
there.
my lord, the professor of Calcutta University in radio physics, he personally mentioned it. And whether it will be upgraded or not, that was uncertain to us. Yesterday evening, we have.
Now see, Mr. Ghosh,
My lord.
we upgrade the matters. Then the other
No,
side.
yesterday, well, I need some people because it's not a motion matter.
Only, my lord, kindly see.
It's not
Order
a motion
dated
matter. My lord,
All right,
opposition.
we will have it next week.
8 January order may kindly be looked into.
It's okay, we will decide it, sir.
No, there is a direction to file the entire record by the Kolkata Municipal Corporation.
Yes, but my lord, I have to produce it. My department has to bring it, my lord.
All right, you bring it next time. Whatever the order is, comply with
My
it.
lord, I shall.
Well, I filed an opposition. I do not know, my lord, whether my land will use. Possibly I have not received.
Opposition.
Yes, my lord.
That the private respondent doing this unauthorized construction?
All
It
right.
is not an unauthorized construction.
Absolutely.
What is the necessity of when my lord is not hearing the matter right now?
Have you want to file your? Show me the affidavit, Gopal.
The copy is yet to be served. একটা copy দিন। না, না, দেয়নি, দেয়নি। কই দেখান কোথায় সার্ভিস করা আছে?
স্যার আমার জুনিয়র আসেনি
আপনার
আজকে।
জুনিয়র আছে বলুন।
না, না,
You
junior
are
is
handicapped
but
সেটা
it is,
বলুন।
sir.
You are handicapped সেটা বলুন। Junior is not here. Supply me a copy.
Everything has been done.
Only, my lord, the last occasion court was kind enough to direct Kolkata Municipal Corporation on 8 January to produce record.
My lord,
And
thereafter,
they are.
last occasion also it
They
was
will produce the
150
record.
number item.
Yes, my lord.
Sorry. Report of the executive engineer is here. Special commissioner is here.
Yes, my lord.
Special officer.
Everything is there, my lord.
Supplementary affidavit is here.
Only the record direction was there to be produced. Without leaving any mandatory space, my lord, they have made this construction. Our easementary right, ancient right of light and air, done.
Hearing হবে এখানে
আচ্ছা, ঠিক আছে, ঠিক আছে।
All right, at the request of the parties, let this matter be listed on next week. No, not next week. 31st.
My lord, only one indulgence on behalf of the, my lord, this gentleman, my lord. Let it be retained in his position on 31st, my lord. Only, my lord, this.
30, we'll see that.
Let it
31st.
be retained in his position, my lord.
রিপ্লাই ফাইল করব কোনো টাইম না
আমাকে একটা দিন।
তাহলে আমি তো দেবো
আমি
Sorry,
করে দেবো।
31st.
দিয়ে দিন। আচ্ছা, copy
31st.
My lord has made the matter returnable on.
31st March.
My lord, I'm obliged to lord.
Come with the records, huh?
My lord, I shall.
আবার একজন হবে
My lord, before that, one inspection, my lord, so far the record is concerned, subject to lordship. Deeply.
That's for me to see
Deeply.
the record.
May it please your lordship, my lord.
Yes.
I am appearing on behalf of the writ petitioners. My lord, my grievance before your lordship is that by two long-term leases, my lord, I have purchased 2 sets of properties, but the Kolkata Municipal Corporation, my lord, is not putting my name in the municipal assessment records and is not issuing the municipal certificate, which we call as the mutation certificate.
Who's appearing on the other side? Mr. Ghosh, are you appearing in this?
No, not in this.
My lord, Mr. Gurudas Mitra was appearing on the last occasion. Your lordship will find from the order of 22nd April.
You are appearing, madam?
No, my lord, I'm not appearing, my lord. He's addressing court. number
Along with
14.
Mr. Shopon Kumar Devnath.
Where is he? This pleadings
Upgraded.
are complete, right?
Yes, my lord, pleadings are complete.
Yes. Where is he?
My lord, he's addressing the court number 14, my lord. There is a contempt matter. I'm the junior there. Since
Like-
I'm here, he has to be there.
Lord, will I come back at 2 o'clock if so pleases your lordship, or we may also come back tomorrow if it is
Tomorrow, original site is only on Thursdays, 31st.
31st.
Let this matter,
To pull it
at the request of the parties, let this matter be listed on
Lord, may it retain its
31st.
position, my lord.
31st.
Lord, may it retain its position. Deeply obliged.
Yes, one my lord was an order, my lord, of demolition was passed, my lord, as by way of an interim order in connection with a proceeding at Nico House.
Yes.
Now, my lord, I am the owner of a portion of the upper floor. I purchased it from the liquidator who has sold it in a company sale. Now, my lord, in these proceedings, my lord, apparently the proceedings are continuing because there are a number of deviations. The corporation is unable to trace out plans, sanction plans. There are sanction plans still a particular floor. There are floor plans for the other floor as well. There's a complainant who says that all unauthorized floors should be demolished. His building has been standing for at least the last 40 or 50 years. There are plans. Corporation is in the process of assimilating these plans from the various departments. They also admit that the plans are strewn all over the place. In the meantime, proceedings are going on before the special officer. In the
How come
proceedings,
the plans are all over the place?
I'll tell you, Lordship, why. These people, it's very peculiar, but because I have some information about this, they, my lord, decided, my lord, midway, everything that happens, my lord, here happens in fits and bursts, and it's an overnight knee-jerk reaction. Suddenly, one morning, they decide to digitize all records. When they decide to digitize all records, the first thing that is to be done, anyone does it anywhere, is make a manual or make a compilation of all the physical records. Make a compilation, make an inventory, and then one by one digitize them in accordance with chronology. But one fine morning, someone woke up and said, we need digitization, because he had to show someone else that this process is going on. So they started clutching at certain files which were available and randomly made digitized records. When they made digitized records, they disposed of those physical files. They moved it away. As a result, today, the things are in shambles. You will get, let us say for 60 Baligan Circular Road, you will get a plan. For 61, you may not get a plan because that has not been digitized. This is the condition that happens. Everything that happens not in this part of the globe happens by knee-jerk reaction. Someone wakes up one fateful morning, decides that the tea wasn't good and puts in a policy. And that policy then goes haywire. I have been a victim of this. I'll tell you, Lordship, why. The plans are strewn all over the place. Plans in respect of the 4th story are present. The other stories have been existing there since the inception of the building. The building was sold in a company sale, part by part. I have purchased the portion. I am owner. I am not given any notice, but 400 subsection 1 says person at whose instance has to be given notice. And I am not a person at whose instance. So there are certain judgments which will be shown which say I don't deserve a notice. I would humbly beg to differ, saying that I am a person holding title to a portion. As it is by the general principles of natural justice, I get to have an opportunity of hearing whether the statute gives me or not. It's only if the statute forbids me that I am shut out. That is the law. So in the meantime, proceedings are initiated. The corporation's special officer, being the delegate of the commissioner, is in the midst of gathering evidence from the department itself. Give me the plans, etc. he has also called for a structural stability report to be filed in respect of the entire building. He will consider everything and pass final orders. In the meantime, on the fateful day, almost by an interlocutory order having final consequences on me,
Yes.
the 7th floor is directed to be demolished. The entire proceeding is at large. Even as I submit, the proceeding is pending. My 7th floor portion and other 7th floor parts are directed to be demolished by the impugned order. And after the direction of demolition, a posse of policemen come along with corporation officials and say that I'm going to pull it down. I rushed to this honorable court. I could have gone to the tribunal, but I rushed to the honorable court because I didn't have time. I had to come. I had mentioned this honorable court was graciously pleased, my lord, to admit the petition and to grant interim orders. Now I say I'm ready to go to the tribunal because this is an order of demolition. I can go to the tribunal if this limited protection is given to me, that let us say for 2 weeks, nothing will be done. In the meantime, I go and file before the tribunal. This period, my lord, I will plead that may be discounted for the purpose of Section 5 and I will sail through there. Now the corporation, my lord, through Mr. Ghosh is taking the plea that you are not a person aggrieved with the meaning of Section 400, subsection 3 of the Act, because you do not have any right over what is unauthorized. I am submitting that till today, it has not been decisively found that any part of the building is unauthorized. The proceedings are at large. Suddenly, this chopping off of my head in respect of the 7th floor was a complete arbitrary action.
7th floor building.
It's a 7th floor building, I am told. Entire floors are existing from quite some time. This is not a case of a construction having come up 2 months, 1 year, 2 years before. I have purchased that portion in a court sale. I don't say that lends it validity, but I purchased it in a court sale from a court-appointed liquidator who sold parts and portions of the Nico building, which belonged to the erstwhile very famous Nico Corporation. Now it went into liquidation. It's been sold. I've purchased. I've got my name mutated. I'm paying taxes. Now today I am staring at that. I am ready to go to the tribunal. Corporation on the last occasion took the plea that, sorry, you are not a person at whose instance the construction was made. You don't have any right to be heard at the trial forum. And regarding the appeal, it's only the person at whose instance who can file an appeal before 400 subsection 3. If that is the plea taken, I had initially, my lord, thought that I'll contest the plea. And I'll show before your lordship there are judgments that where we have not been able to assist the court properly. So there's 1 or 2 judgments which says that appeal should be restricted only to persons who are at whose instance for the purpose of trial forum. If you're not heard with the trial forum, you can't file an appeal. There is a division bench judgment. I will not fail to assist the court properly. That judgment is there, I'm aware. But if they today take the plea that no appeal at my instance is maintainable, then automatically this writ petition would be entertainable for the purpose of seeing whether there are any violations. So if Mr. Ghosh wants to proceed with the plea, I can proceed here and now and show your lordship, my lord, that there is manifest arbitrariness. In the event Mr. Ghosh has been instructed to permit me to apply before the tribunal and see whether I can challenge this order, my lord, in appeal, which right I believe I have as an owner of a premises which is under the cosh, then I think, my lord, this entire thing can be avoided. My lord, I am leaving everything, my lord, to Mr. Ghosh's good office, his wisdom, which is definitely more than mine any given day of the week.
There is no scope to exercise my good office on the face of different judgments of this honorable court.
Then, my lord,
I cannot.
he won't. Then, my lord, may I just do this?
Will not be doing
My lord
justice to myself.
Yes, no, that's all right. Perfect. I mean, that is a good thing with Mr. Ghosh, my lord. There is no dilly-dallying with him. It's either switch on or switch off. He switched it off. My lord?
Not always.
Not. Let us say in this case. Okay, we'll only we'll restrict it to the facts of this case. What I therefore, my lord, humbly submit is this.
Sometimes makes my life very difficult.
It becomes very difficult, I tell you, lordship. When we assist your lordships and we go round and round in circles.
It takes me round and round.
Mr. Ghosh, my lord, I used to assist him, my lord, in a lot of matters, my lord, in my fledgling days when I was part of the corporation panel.
And the best is he's so familiar with the entire, law.
So he can
actually stretch you all over the place.
And he'll take you for a ride. And chances are that once the entire circle is complete, the code issue may have gone. But luckily, my lord, he then brings you back to the core issue.
He can.
Yes, he can take you left and right and bring you back again. So, my lord, only one prayer, my lord, I had. If it is a question of law, my lord, I'll argue that question of law. My lord had told me to come prepared on the last week for this.
Yes.
I have failed your lordship to a certain extent in not getting, my lord, all those judgments today. My lord's interim order is only till next week. Kindly let it remain next week. I'll come with all the judgments. There's a division bench judgment of Justice Orijit Banerjee sitting, my lord, with I think Justice
That you
Rai
pointed out
Chattopadhyay.
last time also,
There's a division bench judgment which Apurva Sinha Rai, which is against my proposition, which has seconded a judgment which has been passed singly by Justice Jyotirmoy Bhattacharya, where his lordship was of the view that any person who is not a person having an opportunity of hearing at the trial level does not get an opportunity of filing an appeal under 400 subsection 3. Now, those judgments are in my reciprocal submission, perhaps delivered by inadvertence owing to improper assistance rendered at the bar, because the main
you also have to see that as is where is basis, because if you have bought the property in
yes. So I can't beg for an improvement. So whatever I get. That Justice Chandrachud's recent judgment is absolutely clear now. As is where is basis means anything and everything that is obtaining in the property, you get that. By that sale, there is no purification or no exaltation of right.
Demolition order has already been passed and you have purchased subsequently.
Then you are gone. Then you're absolutely gone. But here in this case, luckily, my purchase is much prior. And I have not been given an opportunity of hearing. The question which is to be asked in natural justice issues is, what is the adverse civil consequence, as I was submitting on the earlier occasion? We, my lord, at the bar posed the wrong question and gave a wrong answer. The question we posed was whether one has a right to property under section article 300A in respect of unauthorized constructions. And then we answered that question saying that by a division bench judgment of this court, it has been held that unauthorized constructions don't carry any right to property, and therefore anyone in possession of unauthorized construction need not be heard. That was the inference. We have failed your lordships, my lord, at the bar in not assisting your lordships by framing the proper question. I've seen there's a catena of judgments which says the testing feature is whether you suffer an adverse civil consequence. For instance, I am a squatter sitting on the public pavement. I've been squatting there for 20 years. Even if any authority takes any step, I am entitled to an opportunity of hearing in the matter. That hearing may not make me a permanent occupant of that place, but I can't be taken out because I suffer an adverse civil consequence. Till yesterday, I was there in possession. Today, my possession is going. So that's the limited purpose for which Section 5, my lord, natural justice comes in. There are judgments in this domain also, which perhaps we had not cited by way of inadvertence before the Honorable Division Bench. So, my lord, I'll request your lordship, my lord, to go into that issue maybe next week. Only one prayer is, again, my lord, I'm submitting, in the event this can be averted and I can go to the tribunal with all points open, I can go. But Mr. Ghosh he's not ready for a long walk. He's taken the short walk now. So
it's a long walk for me. So we'll have it.
Whenever your lordship keeps it, I'll come ready with the judgments. I'll try and pre-share them so that he comes ready with them also.
31st July.
This matter may take some time. You also may at a time may be fixed at from which it could be because at 12 o'clock or 12:30 as you lost.
Or maybe the second half, because in the first half, then my lord can take up
this
regular
will take
matters.
some time. First half, 2 o'clock.
2 o'clock should be fine.
2 o'clock on 31st.
If in the meantime Mr. Ghosh wants to file an affidavit without prejudice to maintainability,
there is no necessity because
fair enough. I'm no one to suggest. I was just wondering aloud.
There's no need for that, Mr. Ghosh?
No, I have submitted a report as your lordship directed. Report explains all of that.
There's no difficulty. Well, let it not be said then that I was not given an opportunity to file an affidavit. That's the only thing. I'm not suggesting by his client, not by Mr. Ghosh. Mr. Ghosh is very fair, he'll never say something like that.
All right. So we'll have it on 31st.
On the 31st. Not my interim order is still next week. That's the 24th. So, my lord, if your lordship can give me a very short extension so that I'm covered.
Interim order.
Interim order?
19th March.
19th March 2025, it was granted. Extended, my lord, thereafter.
Interim order granted earlier is extended further for a period of 3 weeks or until further order, whichever is earlier.
Oblige, Your Lordship. Let me come back.
Lordship, in this matter, Lordship, Mr. Shondipan Banerjee is appearing on behalf of Kolkata Municipal
Yes.
Corporation, Lordship. Lordship, please kindly allow us a short passover, Lordship.
My lord,
He is engaged in court.
this
number
is at
26.
my instance, my lord. I have a very innocuous and harmless prayer before your lordships, my lord. My lord, the prayer relates to, my lord, amendment or my lord, correction of the, my lord, municipal assessment book, my lord.
Mr. Banerjee is not here.
Lordship, he is engaged in court number 26, Lordship.
Not today. We'll have it on 31st.
My lord has come, my lord has come.
Yes, sir. Mr. Banerjee, sir.
My lord, on last occasion, my lord,
Who has not been made a party to this case.
my lord, I feel not required, my lord.
His second appeal has been dismissed.
Yes, yes,
He is
that is
suffering
not the
a
subject
different
matter.
Yes, Mr.
He has not
Banerjee.
made me a party.
My lord, kindly have a look, my lord. My lord, kindly have a look to my application, my lord. My lord,
So you make him a party, why you have not made him a party?
my lord, I made party the person concerned. Who's my lord? Who's
No,
my
this
lord
is
license?
only to have a litigation
No.
fought out.
No,
nothing.
my lord,
Then
my
make
lord,
him
my
a
lord,
party.
my lord, kindly see, my lord.
Sir, make him a
My lord,
party.
my lord appeared. I have no objection. He appeared.
Make the landlord a party.
He will assess the court. My lord,
No, make him a
my lord, kindly leave be granted. My lord, today, here and now, my lord, made him party.
No,
No
make-
problem, my lord.
Already police will go and evict him. And at
You
this
make him
stage,
a
he has, instead of
Evict
filing,
him. What,
instead
my
of
lord?
filing him,
My lord, what he is,
my lord, he
my lord,
filed this.
Sir, make him a party.
my lord, yes. My
Make
lord,
him a
I am
party.
making party, my lord, by
We will
the
have,
leave of your lordships.
we will
Today,
have,
here and now, my lord.
I'm not hearing this today. Make him a party first.
The last occasion, my lord, then an advocate for
add the landlord as a party to the present writ petition. What is the name? Give the details.
My lord.
My lord, may I correct it by inserting the landlord's name as a party?
Yes.
My lord.
Let him make the correction. List this matter on.
ডিগ্রিতে হবে তো ডিগ্রি যেটা
এখানে আছি নাকি?
7th August.
চারজন পাঁচজন ল্যান্ডলর্ড আছে ডিগ্রি আমি দিয়ে দিচ্ছি
7th August.
Grateful, Lordship. Shall I give my name?
Yes. After you become a party.
That is why I'm asking your Lordship. My Lord.
May I please to pay for the petitioner, my lord. Very short matter. May I, my lord?
Yes.
I am in the occupant of this first floor of the premises since 1985, paying the taxes and all. In 2013, there was an order by the hearing officer who assessed the property of some value of around 9 lakh and all and fixed the taxes and all. So we preferred a writ petition which was dismissed against me. Then we preferred an appeal. That appeal was also dismissed. That is appearing at page 42. Madam, may see to that also. Madam, may appreciate page 42 of my writ petition. The division bench says, since the petitioner did not choose to prefer not to file an appeal, so this does not materialize.
Where is it, Mr. Mukherjee?
42.
Page 42.
My lord. Para 23. Since there was an order of hearing officer, so I need to prefer an appeal. 85. So I chooses not to. So I acceded to that. I considered to that. I paid the amount 20 lakh rupees and odd. Then thereafter, what happened in 2023? There was a fresh assessment, and they have given me a notice that is appearing at page 51. 51 of my writ petition.
Yes.
Now, can you see the date of the notice is the bottom of the page, 5th December 2023.
I got it?
Yes.
Then kindly see before that paragraph, the annual valuation of proposed due to ground as stated and so and so. Municipal Commissioner will proceed to consider such valuation on 24th December. Then the third line from the bottom, please note that if you do not file any objection to the aforesaid valuation within 24th December 2023. So I have preferred an objection that is appearing on the next page only, 19 December. So I preferred an objection within time.
Yes.
So they chose not to respond to that. Now, why they did not respond? Kindly see the next page. Before I could have raised my objection, they have already uploaded my valuation. Kindly see the next page, page 53. The last column. That is on 17/11/2023. Before they could have responded to my objection, which they have requested to me. As before allowing me to appear before the hearing officer and to get my grievances canvassed before, according to the section 187 of KMC rules, KMC Act. So thereafter, what happened? I have made a representation also on page 44. This is the last representation we made.
Yes.
This also became unattended. They did not respond to this also. Now, where my grievances is that I am not asking any favor. I am only asking KMC to be reasonable. Kindly see page 54. Page 54 my petition. This is the quarterly tax for the rest of the floors. Kindly see the first line, Shelter Infra Projects Limited. This is 16,180 rupees, full second floor, same square feet. Now the next third floor, 40,348. Now the fourth floor, so and so. Now kindly see my assessment for quarterly. I've got it.
Yes.
So before that page 53, which my valuation they have done is that assessment of tax, that is around 1,64,091 rupees.
Your company, Mr. KL company, right?
Yes. Here my grievance is, but I am not asking any favor. There must be some reasonableness. They must be reasonable. And they did not allow me to appear before hearing officer even. Well, let them consider my representation and allow me to appear before hearing officer. That is the only small point.
Only I'm submitting that you are supposed to submit the return under the unitary assessment. You also can see the notice matter which has been issued, each matter 51. There is a prescribed form in which, my lord, the assessment return has to be filed by the assessee.
Yes.
This is a new system, my lord, introduced, you also knows, my lord, with effect from first quarter 2017-18.
Yes.
He did not do that.
Yes.
My authority, as it appears, my lord, exercise their power because they can, my lord, proceed unilaterally. In the event they are not, because 2017 it was ought to be done, that is 2025. Now they have, my lord, assessed the property by themselves. Now, whatever the objection, of course, my lord, my learned friend could say that in whatever way I have written something, my lord, regarding my objection, you could have disposed in either way, rejecting or accepting whatever. That represent does not contain anything which, my lord, is required to be, my lord, informed to the authorities, my lord. But I will ascertain, my lord, I will ascertain because, my lord, so far as this particular period is concerned, with the period of 17-18, I will, my lord, intimate to your lordship on the next occasion what has happened, why they did not give in hearing. But so far as the valuation period, earlier to this, the unitary assessment, the valuation that has been finally settled up to the order of division bench. Now they have not prepared an article possibly, my lord. But a huge amount is lying outstanding. He can say, my lord, regarding whatever the amount is lying outstanding, that not relates to only this period of assessment. Because he is to go on, my lord, paying the amount on the basis of the annual valuation already decided. But I'm not saying, my lord, about that. He's raising an issue that this period, the annual valuation of this period, therefore, he ought to have gone to make payment up to this year. Now, my lord, what about the balance that is to be required to pay to us? Well, I am not asking, my lord, regarding that balance amount to be paid right now.
So you consider his representation.
That will, my lord, that will I will consider, my lord.
Because you have not considered his representation of 19th of December.
Well, you know, I take him, I will ascertain because that information has not come next day, my lord, I will inform you, lordship. Because if it is not, of course, my lord, they have to consider and pass an order appropriate. If necessary, they will give a hearing to my lord.
All right, then not today. Not today. 31st. Give it for 31st.
I'm grateful.
I beg to appear on behalf of the petitioner. My lord. My lord, at a point of time, Kolkata Municipal Corporation recorded our name. Subsequently, my lord, there are certain complaint, and on the basis, while adjudicating that complaint, Kolkata Municipal Corporation deleted our name from their assessment book, inspection book, assessment register. My lord, the impugned order, which I have challenged before this honorable court, is page 45, 46 onwards, annexure P8. My lord, and I'm not reading, my lord, each and everything of this 4 pages order, but they are heavily relied upon, my lord, on the basis of their own finding and come to a conclusion this is a Thika property. My lord, the adjudication of Thika property is to be ascertained by the Thika controller itself.
Yes.
At a point of time, it was by the civil court. Thereafter, Amendment Act was amended and it was vested upon the Thika controller. In spite of that fact, lordship, kindly see page 48, middle portion. Upon hearing the parties to the hearing officer, Deputy Assessor Collector North, by order dated 17/5/2022, has inter alia held as follows. KMC will decide on prayer of Pradeep Boshak and others for conversion of Pakka premises number 5B Bagmari Road to Thika Bosti premises number B5A/H/9 Bagmari Road after taking valuable opinion and suggestion from the law cell of KMC. Instead of Thika controller, they are heavily relied upon the law cell of their own. But they are assuming this jurisdiction in this fashion. Then, my lord, I am reading this 1.5 page. Accordingly, the matter was placed before the CMLO, Chief Municipal Law Officer. Aforesaid note of administrative department goes to show that Bosti premises being number was converted to Pakka premises being number so and so with effect from 4th quarter 1987-88 by the order DMC, it means, my lord, Deputy Municipal Commissioner Revenue. Possibly he is, as far as rank is concerned, above the CMLO. Headquarter dated 10/8/1998. Material as placed on record go to show that the controller Thika tenancy by order dated 22/6/1998 held that the structure standing on the premises number so and so vested to the state West Bengal, free from all encumbrances, with the date of his order, this order, after inter alia observing as follows. My lord, this is to be, my lord, I require to make this submission in the year 1998. The adjudication whether a particular property is Thika or not, that to be decided by the civil court. At that point of time, lack of jurisdiction of the Thika controller also. From the deposition made by both sides, the document, Xerox copy of sale deed so and so, my lord, the copy of assessment roll of CMC, and the report of regional office. Regional office means, my lord, Thika controller. It appears that disputed land is a Bosti land which comes under the provision of the CTT Act, Calcutta Thika Tenancy Act 1981, and the transfer of the said property stand on the premises by way of a sale deed has taken place in violation of section 6(3) of CTT Act and its amendment of 1993. My lord, there was no civil suit in the civil court challenging this particular transfer, and for declaration that this was forged and fabricated document, my lord, this was prepared in this fashion in violation of the existing rule of law of the land, my lord. Then, my lord, turn to next page. 6(3) of the Calcutta Thika Tenancy Act 1981 and its amendment on 1993, the shoot Oh, acha. No, my lord, thereafter, my lord. Acha. My lord, I am drawing lordship attention, page 49, last paragraph. Last but one. The shared suit was dismissed on contest on 2nd April 2002. The said order was carried to the judge of Small Causes Court, Shialda, at the instance of Horigopal Das by way of a preferring title appeal number 5 of 2005. The learned appellate court by judgment dated so and so has been pleased to dismiss the appeal on contest being devoid of any merit, after, amongst other, observing as follows. My lord, this title suit, my lord, before the Small Causes Court, an appeal relating to the eviction of the tenant, that was dismissed, admittedly. Appeal preferred, that was also dismissed. So, but the character of this particular premises, whether it's Thika or not, that was not the subject matter of this, my lord, civil suit. Then, my lord, they come to the conclusion. Now, in the memo of appeal, the appellant, my quotation of that particular order has pointed out that appellant plaintiff has already filed so-and-so against the state of West Bengal and controller of Thika tenancy, praying for declaration the suit property is not a Thika tenanted property and the appellant plaintiff is the owner of the same. Mere filing of such suit ipso facto does not change the present status of appellant plaintiff. The observation and language of the order passed by the controller Thika tenancy is absolutely clear. The observation made by the lower court that in terms of the order passed by the Thika controller, the suit is not maintainable, does not seem to suffer from sort of irregularity. Lordship, I am drawing lordship attention, page 37. Page 37, my lord, I have filed one case before the, my lord, the civil court for declaration and permanent injunction, declaration that this property is a Thika property and that suit was, my lord, decreed. Page 34, my lord, starts from 34. I am reading, my lord, 36. My lord, here, lordship, my lord, lordship, I am reading, my lord, I may excuse, page 34, first, second, third, fourth paragraph. Plaintiff case is sought that the plaintiff has become the owner of the suit property being premises number so-and-so, Kolkata, a registered sale deed so-and-so executed Sheikh Mazahar Ali and 19 others. After purchase, the plaintiff mutated his name before the KMC and paying tax to the corporation. So, my lord, is the Pakka construction, Pakka structure, and I have purchased the property from a particular person. Then, my lord, there are monthly tenants in the premises under the plaintiff, and the plaintiff jointly attempted to grab the suit property by not paying monthly rent. My lord, the tenant, sir, not plaintiff. The plaintiff was completed to file ejectment suit against some of the tenants. Some of the tenants, with a view to grab the suit property, file an application before the controller Thika tenant, wherein they challenge the sale deed on so-and-so ground and transfer so far made by the vendors of the plaintiff. And the defendant, without going through the sale deed, most illegally passed an order by stating that land is Basti land, which comes under the provision of the Calcutta Thika Tenancy Act. Moreover, the transfer of the said property by way of a sale deed has taken place in violation of 6(3) of the CTP, amended 1983. The premises number so-and-so, my lord, Calcutta 84, stand vacated to the state, stand, my lord, vested possibly, my lord, not instead of vacated, should be vested to the state of West Bengal, free from all encumbrances. That the Thika controller has no jurisdiction to decide the right, title, interest of any party. Also, the Thika controller has no jurisdiction to decide whether the property in dispute will come within the jurisdiction of Thika controller. Then, my lord, turn to next page, page 36. My lord, by the illegal order of cancellation of the sale deed and vesting of the land by declaring the state suit premises as a Thika tenant premises, cloud has been casted upon the right, title, and interest of the plaintiff in the suit property, who has become owner of purchase on payment of consideration money. Hence, by filing this title suit for declaration that the plaintiff is lawful owner of the suit property, and also seeks declaration that the plaintiff property is not a Thika tenant property, accordingly beyond the purview of CTT, plaintiff also seeks a declaration that the acts and deed and decision of the defendant number so, two, in respect of the suit property, my lord, under order dated so and so is illegal, void, collusive, inoperative, beyond jurisdiction, is not building upon the plaintiff, not binding upon the plaintiff. It's instead of binding, building retreat. In support of the contention as made of the plaintiff, my lord, in evidence so and so, my lord, then my lord, on perusal of record of 82 of CPC, my lord, and then finally this suit was decreed ex parte, and the order was challenged by the state government, that was also dismissed. Now, our humble submission, this assumed finality, order of the Thika court cannot be changed by the neither Kolkata Municipal Corporation nor, my lord, the Thika tenancy controller. The question of jurisdiction of the Thika controller, my lord, 1/11/2010, My lord, the controller has given power. My lord, I am reading, my lord. কেন ওটা দেখালেন 5-3 দেখাবেন তো কোথাও বার করে দিলেন my lord I may be allowed my lord to read from the Thika Tenancy Act 5(3). My lord, this is the Thika Tenancy Act. If lordship Lordship, my lord, 5 incident of tenancy in respect of the land vested in the state. Now, my lord, 3 may kindly be looked into, and my lord, 3 inserted in the particular book on 1/11/2010. At the bottom, it is written. Lordship got it. If any question arises as to whether a person is a Thika tenant or not, whether the land in question is a Thika land or not, the controller either on his own motion or upon receiving any information may, after giving a person interested an opportunity of being heard and after examining all such document and particulars as may be considered necessary, inquire upon and decide such question. The interest of the Thika tenant holding directly under the state, my lord, turn to next page, my lord, shall be heritable, shall not be transferable, and all these things. Our humble submission, my lord, only in the 2010, the Thika controller has given this particular power to adjudicate this question. In the year 1998, they have made certain observation. My lord, this observation is beyond jurisdiction. I intend to rely upon one judgment only, my lord, and then I will conclude my lord, submission. Then, my lord, the Kolkata Municipal Corporation, my lord, is not the appropriate authority in any manner whatsoever. There may be a dispute between the civil court and Thika controller, who is actually, my lord, authorized to pass order relating to the Thika, up to which age, up to which year, my lord. But the KMC has no such power. KMC only mutating the name in the record of the Kolkata Municipal Corporation for payment of taxes, and this is only question. Title cannot, my lord, neither create nor extinguish in any manner whatsoever. The limited role to play, only to realize and, my lord, to take action against those who are not paying taxes to the credit of Kolkata Municipal Corporation. My lord, I am reading one judgment, my lord. This is the division bench judgment. But I am just reading and handing it over. Since the jurisdiction to decide an issue as to whether a person is Thika tenant under the landowner in respect of the property or not was exclusively vested under the aforesaid 2 acts with the civil court, we have no hesitation to hold that the initiation of the proceeding before Thika controller was illegal. Consequently, the order which was passed by the Thika controller and learned tribunal as aforesaid are nullity. My lord, this is, my lord, page 109, last.
109
না
আর এটা judgment
আচ্ছা আচ্ছা আপনারা ওইভাবে করছেন না পেজ my lord internal page is my lord 1 2 3 my lord the last 2-3 paragraph my lord maybe excuse me only one copy my lord
marking
my lord is a marking also I
আগে কি দিচ্ছিল আমাদের দেওয়া
আপনি জানেন
যাই না
this is my humble submission আর তো কিছু না আর বেশি বলতে যাবো ভালো না
Yes, sir.
Primarily, as I understand, my lord, his grievance is against the order of the Thika controller. Well, if the property is vested to the state after the
No, his grievance is against your order.
well, he's annexed my lord, our order, but that has been done on the basis of the order of the Thika controller.
Yes.
Which has been intimated to us because the illogically see the page my lord 50, next page.
Yes.
On the basis of the order as order of CKTT, Thika tenancy, and now West Bengal. Order. Dated 22nd June 1998, and opinion of the Chief Municipal Officer, dated 28th May 2022, as note page number, the proposal for conversion of the Patka premises of 5B Bagmati Road to Thika Bosti premises. Number Sergeant said Bagmati Road is initiated with effect from 4th quarter 2010-11. The following quarter of the existing assessment with effect from 3rd quarter of 2010-11. Then it has been recorded. His grievance is that recording of the state of West Bengal represented by the recorded owner, state of West Bengal, represented by the controller, Thika tenancy under Calcutta Thika Tenancy Acquisition Regulation Act 1981. Well, under this act, well, knows automatically vesting takes place. that vesting took place. Now it was definitely appears to be an issue before the Thika controller as per back as well, 1998.
Yes.
He states that he has purchased the property. The answer to be given, if the Thika controller says that it is not their property, we have no issue. We can delete the name of the state of West Bengal from our assessment record. We can brought his name on record once again. Therefore, Thika controller has been made a party. Thika controller has to answer whether it is a Thika property or not, whether it is vested or not, and what is the decision which was taken in 1998.
Where is that?
Thika controller is a party here. 1998, there is a reference in this the page.
Where is the order of the Thika controller?
In 1998, at that point of time, no power with the Thika. Only in the 2010, Thika has entrusted.
No, sir, but where is the order of that?
My lord, that order, my lord, they have referred this. Lord, you will find, my lord, page 48.
So you are saying that the Thika controller had no power at that point of time to pass any order as far as Thika tenancy is concerned. Right? That power was vested in the civil court.
Yes, at that point of time.
At that point of time.
2010 onwards, my lord, the power with the Thika controller. 5.3 has been amended or inserted. And my lord, they have referred one case, my lord, only 47 bottom may kindly be looked into. This is a eviction suit. They are trying to, my lord, to collect the material from the eviction suit, page 47 at the bottom. In another suit, title suit number 724 of 1995, while dealing with the preliminary issue, landed civil judge filed by the transferee purchaser, Sri Horikopal Das, against the Nitai Bosak for eviction and recovery of khas possession. So, my lord, here what happened, what observation has been made by the civil court, that was, my lord, used against me to delete my name. Whereas, my lord, the ex parte order passed by the civil court, assume finality, not challenged by the KMC, not challenged by
Delete
the...
your name. What is the status of the property? It is a Thika property or not a Thika?
Well, my name is recorded, and thereafter they have deleted my name, deleted
They
my...
have deleted your name only on the basis of a judgment. They have not deleted it unilaterally.
Yes, my lord.
That
Here,
is an
my lord,
order.
they have exercised that power without taking...
Then you challenge that order of 98. Where the Thika, if at all, you are saying.
1998
in
order.
1998, the Thika controller had no power to pass an order, and only subsequently in the year 2010, they have been vested with the power to do that. You challenge the order of 1998. All right?
It is there. It is there. Page 34.
So what is the outcome of that, sir?
Page 34, my lord, civil court held that
Thika
no power at that point of time.
That's the observation, my lord.
That is just an observation. That will not help you.
Now,
you get the order reversed. Where is that order which has been challenged?
The 37 plaintiff do get a decree of permanent.
Sir, this is not that order.
Yes,
where is the order which has been challenged? 98 order.
Kindly consider we have made Thika controller party over here.
Sir,
they are, my lord, reluctant to come here. And my lord, on the basis of Thika controller observation, KMC has no authority.
Sir, you have to challenge that order of 1998. And if that has been wrongly passed, whatever that order is today, that holds ground unless and until it is set aside.
So, my lord, without any jurisdiction, my lord, Thika controller
whatever
has exercised this power.
You challenge that order.
My lord, here, my lord, humbly, most respectfully, I am submitting Thika controller is a party over here. Let, my lord, them direct to come forward with their affidavit, my lord, and then kindly decide the whole issue. And my lord, 99.
They will not do anything. Why should I direct them?
Well,
to challenge the order of 1998.
Consider, my lord, after, my lord, 25 years, my lord, that
whatever it is, if you are relying on that, you challenge it.
That being the difficulty, here, my lord, Thika controller is party. In the event this honorable court thinks it fit and proper to bring them, they are avoiding this particular forum because they know at that point of time no jurisdiction.
Sir, even if they come here, they cannot really file an affidavit saying that the order which has been passed is wrongly passed. Unless until that is set aside. Rightly or wrongly, that order pertains.
And one more question, my lord. Whether KMC has the power to decide the question of Thika?
KMC has not decided.
But they have
not decided. They have only acted on the order of the Thika controller.
So, 88, 89, they have acted on the basis of, my lord, their wisdom. And my lord, the Deputy Revenue Commissioner has mutated my name in appropriate fashion.
You file your report, we'll dismiss it.
Yes, my lord, that being the situation.
Yes.
This is the challenge.
Yes.
This is the challenge for
Yes.
And this particular act is a specified act under the tribunal.
Yes.
So any order passed by the competent authority under the Tenancy Act. There has also been established. So this
এরা ওনার বলছে তারপরে বলছে some of the tenants. This is the issue for the in the title through.
The order ought to have been challenged.
This is the challenge to the order.
First thing. Second, my lord, the suit whatever has been filed was against the corporation and the controller. Now, the private respondent initially declared to get the tenant, my lord. Their eviction
information sheet
that the suit is not maintainable. The appeal court has also
information sheet
only on the ground dealing with the question that whether I am a tenant or not. The order that committee has order has been passed, indicating that we are a tenant. That order remains unchallenged. In their suit, we were not a part. That was passed against the controller Thika tenancy, my lord, during the year 2002, when the tribunal already was established.
Then why should
Kindly consider, my lord. This was
this
was challenged before the civil court, and this was, my lord, the state authority filed one appeal. Appeal was dismissed, and my lord, my learned friend at that point of time only in the civil court.
Why should I interfere in this
We have preferred
writ
appeal.
petition?
We have preferred application
Petition
before the
cannot
civil
lie.
court.
You are
No,
mentioned
sir,
in
but why
the
should
My lord, this is the challenging the order of the Thika controller. This page 34.
No, sir.
Kindly see, my lord. Kindly see.
If the order has been passed by the Thika controller, you should have challenged it in appeal.
No.
What have you done?
My lord, after 2010, that is appeal.
Forget about
My lord, the
2010, sir.
order of Thika controller is before the LRTT.
Even at that point of time,
LRTT was not there, my lord, 1998. My learned friend possibly, my lord, misled this honorable court. Yes, my lord, what happened at that point of time, civil court? I mean, I have challenged it in civil court. And thereafter, my lord,
I don't find any illegality in the order passed by the.
no, my lord, only thing, my lord, at that point of time, civil court. This is my humble submission. Kindly record this, my lord. I have challenged it in civil court. An appeal preferred by the state that was dismissed.
The petitioner has preferred the present writ petition. Challenging the impugned order passed by the Special Municipal Commissioner Revenue dated 20th/6/2022 for conversion of Pakka premises number 5B Bagmari Road to Thika Basti premises number 5/5A/H/9 Bagmari Road. Bagmari Road, was allowed, and consequential steps for amendment/correction in the assessment register were directed to be taken. It is the case of the petitioner that he is the absolute owner of the premises in question. Full stop. The Thika controller, by an order dated 22/6/1998, held that the premises constituted Basti land and accordingly falls within the purview of the Calcutta Thika Tenancy Acquisition and Regulation Act 1981. He further submits that the sale deed in respect of the said premises has been executed in.
Well, may I take a loss kindly, madam?
I need just. Has been executed in contravention of section 6(3) of the said act. Full stop. Learned counsel for the petitioner states that the conversion which has been effected by the impugned order is illegal since the property is not a Thika property. Full stop. He further states that the respondent corporation had no power to amend the assessment record. Full stop. He states that the action of the respondent corporation based on the order of the CKTT WB dated 22/6/1998 is illegal since at that given point of time, the Thika controller had no power to pass any order for declaring a property to be a Thika tenancy property. This is your submission?
What is more, my lord, page 47, I have challenged this, my lord, order of the Thika controller before the civil court. Page 47, top paragraph.
He states that he had challenged the order of the Thika controller. Where is that entire record, sir?
Just on page 47. Page 34 is the, my lord, civil court order, and page 47 may kindly be looked into.
So just one page, sir, one page. What is this one page?
The order goes there. Where is the order?
Where is the order?
What is the order?
Order of the Thika controller.
Order of the Thika order.
Only, my lord, here it is reflected from the order of the Kolkata Municipal Corporation.
Sir, you can't file pages like this. Where is the complete set? You can't file pages like this.
Pages, my lord, there are certain, my lord.
No, sir, then you have to file the complete set.
Yes,
it can't be in pages.
True, my lord.
In tatters.
That is, my lord, internal page. There are difficulties, my lord. So for 46 onwards is concerned. That I have got, my lord. I tender unqualified apology, lordship. This is.
It can't be done like this, that you will put any one pager and then you want the court to rely on those.
True, my lord. True, my lord. True, my lord. True, my lord.
And madam, this is not the order of the Thika controller which you have challenged.
The civil court order. That is civil.
The civil court.
Court's order.
This is basically an eviction proceeding.
No,
my lord, this is
no,
the
this is the challenge, my lord. Page 47 at the top may kindly be looked into for a while, my lord.
Sir, then you file your proceedings.
No.
This can't be done in one page. Please. This can't be done in one page.
One page, my lord. 4 pages order of the Kolkata Municipal Corporation.
You file the, sir, not about Calcutta Municipal Corporation. You please file the entire paper book.
Deeply obliged.
Learned counsel for the petitioner seeks to place on record the order of the, which order is this?
My lord, this order
which one pager is this?
My lord, which page, lord, sir?
Page 47.
Page 47 is the order passed by the Kolkata Municipal Corporation.
You are relying, where is that?
Top, the purchaser, transferee, Horigopal Das had filed a title suit.
Where is that?
Yes, my lord. The order of the Thika controller.
Where is the order of the Thika controller?
Lord, it is also in the Kolkata
Learned
Municipal
counsel for the petitioner seeks to place on record by way of a supplementary affidavit the order of the Thika controller wherein the property under dispute has been declared as a Thika tenancy property. Full stop. Let the same be done within a period of 2 weeks. List after 4 weeks.
Deeply up.
You come up with the judgments. Why file an affidavit? I'll dismiss it. I'm inclined to dismiss it today only, but I just want to see that order.
Item number 11.
I appear for the petitioner, my lord. This is my second round of writ petition, my lord. On the last occasion, KMC sought for time to file their report.
I am ready with the report, and by virtue of that report, the writ petition has become infructuous.
My lord, I am on behalf of respondent number 7, 8, and 9, my lord. I am praying for not today, my lord.
Page.
Lordship will kindly. This is my second round of
14.
Page
14. Their prayer.
Yes.
They are A man. Madam, may I read?
Yes.
A writ of mandamus and their main agent so and so to demolish the illegal, unlawful, illegal, unauthorized construction made at premises number so and so. B. A writ of in the nature of mandamus commenting respondents and main agent so and so to comply with the order dated so and so. My lord, in terms of this, we have, if your lordship goes through the report, we have already given hearing. We have already in the matter to the higher authority. That is at the last paragraph of my report. The matter is placed before the higher authority of Building Department KMC for further processing under Section 401 of KMC Act 1980. So I think that grievances have been redressed.
No, that was the status in February 2025 also. Lordship, may I place the order passed by in the first writ petition, my lord?
Yes.
Kindly seize the first order passed in the first writ petition. That is at page 59. As I said, my lord, this is the second round of writ petition.
page 59 at page 60, Lordship will find the learned advocate appearing for the Kolkata Municipal Corporation submits that notices for hearing were issued against the petitioners as well, but they chose not to appear. I am not inclined to dwell in the controversy. As aforementioned, I dispose of the writ petition with the direction upon the Executive Engineer, Building Department, Borough 2, Respondent number 5, to afford an opportunity of hearing to the writ petitioners on December 5. No separate notice is required to be issued. The said engineer shall pass necessary order.
In terms of that.
Thereafter, my lord, a hearing was held. Lordship will see the conclusion of the hearing at page 68. Lordship, I will only place the last portion of the order, my lord. I will not bother Lordship. The matter will be processed under section 401 of KMC Act after issuance of stop work notice under section 401 of KMC Act, my lord. They are supposed to take undertake proceeding for demolition of the building. Now they say that
Same
it's
report.
It's exactly same report they have
Mr. Banerjee, not even an inch has moved.
My lord, that was at report on
Since
8 February
till
2025.
date, same report,
14
cyclo-style,
14 July.
cut, copy, paste report. Nothing has been done.
408 করতে বলেছিল আবার কি আছে?
Nothing has been done.
Well, give me some time. Only 1 week time. I will come with the press regarding 408. I will.
You will kindly direct them to take decision and then file the report.
No, we will come with the report. Final report.
There is a conclusion from them that it is unauthorized.
The petitioner has preferred the present writ petition being aggrieved by the inaction of the respondent in not taking any steps for demolishing the unauthorized construction taking place at premises number 166/A, Ahirtola Street, PS, Jorabagan, Calcutta. Full stop. It is the case of the petitioner that she is the absolute owner of the premises in question, and the private respondents are occupying part of the said premises as tenants. Full stop.
And as
He
not
further
tenants, but
submits
as
that at the instance of the private respondent, unauthorized construction is being carried out at the said premises. Full stop. The petitioner had preferred, the petitioner earlier had preferred a writ petition WPO number 674 of 2024, inter alia, praying for demolition of the unauthorized construction. Full stop. When the matter came up for hearing, respondent municipality submitted a report that demolition of the unauthorized construction is already initiated under section 401 of the KMC Act. Full stop. The petitioner, the respondent corporation further submitted that hearing is underway before the corporation and a decision will be taken expeditiously. Full stop. Learned counsel for the petitioner states that no steps have been taken till date. Full stop. Learned counsel for the respondent corporation seeks and is granted 2 weeks. 2 weeks time to file his report by way of an affidavit. Exception, if any, within 1 week thereafter, list after 4 weeks.
In the meantime, we will start the demolition.
let today's report be also circulated.
What's the point? Same report.
The same report, I understand. Very grateful, man.
No. Give it back to Mr. Banerjee. Mr. Banerjee, I don't want to embarrass you. That's why I'm not taking it, neither I'm recording.
I know, man. I will go and start the demolition. What are you going to
12 is my writ petition, my lord. This is that point where, my lord, the reasonable rent ought to have, my lord,
may I? My lord had been pleased to take this up on the earlier occasion, lordship recalls. Canara Bank is in possession of a portion of the premises. Corporation has assessed the taxes and then apportioned it. Canara Bank has got an apportion in terms of its actual rental in proportion to the entire rental. Canara Bank says it should.
May I proceed with?
Yes, I remember what he
Yes, may I place my request?
Just thinking whether we could come back with affidavit so that my lord can finish it off. This requires a little bit of factual dealing.
I do not stand in the way, only that in the meantime, this will not be given effect to. That's the only thing. Otherwise, we can come back on affidavits and all.
Indicate also, the tenability point is kept open. So far as the Canara Bank is concerned. Mr. Banerjee's prayer is very short. He doesn't, on the other day, if I have heard him properly, he said that I am not joining issue with the valuation. What you are, the accumulated tax, what you are trying to recover from me could also be done from the tenants. So his prima facie thrust of argument is corporation should proceed for recovery from the tenants. Am I correct?
If Canada Bank goes before the tribunal, what will happen? The
Tribunal's difficulty is, tribunal, my lord, is 189 subsection 5. It says that an appeal shall lie against any order of the hearing officer passed under section 188. Now, hearing officer under 187 is constituted to determine objections to proposals of assessment. If he wrongly determines them on facts, then there's the tribunal. Once an assessment has happened and there's a question of apportionment and the like, tribunal doesn't have jurisdiction. It's a very limited tribunal in assessment. In building tribunal, my lord, 400 subsection 1, that's demolition. 416, that is change of use. In these two aspects, one can approach there. There also, but a plan cannot be challenged because a challenge of a plan is under 397 before municipal commissioner. If you fail before the commissioner, there's no other statutory remedy. You have to come up in writ jurisdiction. But assessment tribunal, very limited power. Hearing officer has an obligation to fix the annual valuation upon determining objections. If he has fixed it wrongly, and there are factual aspects which you want to raise, including points of law relevant to the facts, you can file an appeal. Apportionment wise, the tribunal doesn't have any jurisdiction.
But I do not join issues with the exchange of affidavits.
With the point of maintainability, so far as Canara Bank is concerned, is kept open.
Yes, I'll anyways have to satisfy that to your lordship. And also, in the meantime, let them not take any steps pursuant to that order. That's the only humble prayer.
The first writ is Canara Bank's writ. The second writ is the owner's writ.
In item 12, my lord, maintainability point.
In both, my lord, if your lordship so pleases, issue directions for affidavits. And we can come back, address your lordship comprehensively on the
owner's writ is you're challenging the assessment.
That is 13.
In the owner's writ, I am saying I'm challenging recoverability.
He is challenging.
I am saying recovery direct from the tenant.
Apportionment.
Recoverability.
Recollects what he says, that I am holding 5,000 square feet in a building.
Yes.
And paying X amount of rent.
No, owner's writ. Uni bolchen owner's
But could we go item wise? Could we go item wise? Item 12.
Canada's writ. My writ is very simple.
Canada.
Yes. My writ is you are asking for 100 rupees as total tax. You say that the portion occupied by Canada fetches 80 rupees of tax proportionately. You directly realize it from them. Instead of through me. Because through the owner is an enabling provision.
Whether that is possible in law, that's a question to be asked.
That's of course.
Yes.
Everyone will address your lordship on that.
Take down. Both the writ petitions are taken up together since the property in question is the same and the assessment orders have been passed for the same property. Property is the same, right?
Property is the same. Common questions of law and fact would also arise.
For the same property. The petitioner in WPO number 285 is assailing. You are assailing the order dated?
Yes, we are both assailing the order of apportionment.
Page 56.
Date ta bolun.
Owner's writ petition. This is
Dated.
I take your
Order dated
28/5/22.
28th of May 2022.
Yes.
18th.
18th.
Oh, sorry, 18th.
Sorry,
18th.
18th, I'm sorry.
18th May 2022.
ওই দুইটা এমন ভাবে লিখেছে।
Petitioner,
এখানে
the petition, the present writ petition is assailing the impugn order dated 18th May 2022, passed by the assessor and collector
কোর্ট ফি পেয়ে হলে দেখলাম কোটা কোটা লিখে।
in compliance with the direction issued by this honorable court in orders dated 3/2/2015 in WPO number 209 of 2014 and 9/6/2015 in WPO number 555 of 2015. By virtue of the said order, the assessor and collector has made an assessment in respect of premises number 7, Red Cross Place, with effect from second quarter of 2012, comma, whereby the petitioner, being a tenant of the said premises at the relevant point of time, has been held to be liable to pay an amount of rupees 4,15,000. What is the amount which you have to pay? 41 lakhs. No, my lord, 4 crores 90.
4 crores?
I'll give your lordship the exact figure, my lord.
4 crores 15 lakhs. 4 crores 15 lakhs.
4 crores 15 lakhs 30,781.
781.
Out of the total outstanding of 4 crores 75 lakhs 89,152. It is the specific case of the petitioner that they are occupying only 5,541 square feet out of the total area of 55,379 square feet, comma, merely 9.66% of the premises, full stop. However, they have been made liable to pay approximately 80.95 of the total demand, comma, which is arbitrary and disproportionate as contended by the petitioner, full stop. The issue involved in the present writ petition pertains to the assessment of the premises in that's it. All right. In view of the said submission, learned counsel for the respondent seeks and is granted 2 weeks, 4 weeks time to file his affidavit in opposition. Reply to the same, if any, within 2 weeks thereafter. This is 285. Mr. Banerjee, you want to file your reply in this?
Yes, Lord, I
Also,
I'll in my petition
learned counsel for the private respondent. Respond number?
I am respondent
5 to
number
10 in
5 to 10 in the first.
Sanction is granted. 5 to 10. Sanction is granted. By 4 weeks time to file his affidavit in opposition. Reply to the same, if any, within. This is 285. All right. In 762, the petitioner has preferred the present writ petition, being aggrieved by the notice of demand dated 5/6/2024. 5/6. You are only aggrieved by the notice of demand.
Notice of demand, yes.
Notice of demand dated 5/6/2024. And what is your ground?
I'm saying that the demand should be directly made from the occupiers in view of the fact that they are also persons liable to pay tax.
Full stop. Learned counsel for the petitioner states that the notice of demand which has been issued is illegal, since the same should also be recovered from the persons who are occupying the said building, and that he is not solely liable and responsible to pay the said demand. That's your contention?
Yes, that's more or less.
All right. Learned counsel for the respondent seeks and is granted. For learned counsel for the respondent corporation seeks and is granted 4 weeks time to file his affidavit in opposition. And also the Reply to the same, if any, within 2 weeks thereafter. Learned counsel for the private respondent number.
কত? Then I did this one.
5. Respond number
5. Respond number 5, Canara Bank seeks and is granted 4 weeks time to file his affidavit in opposition. Reply to the same, if any. Reply to both the
affidavits, if any, within 2 weeks thereafter. Let both these matters be tagged together for hearing. List on after 8 weeks. After 8 weeks, Ekta, Gopal.
One indulgence, my lord, if it so commences to your lordship, kindly stays the operation.
In the meantime, Mr. Mukherjee will stay the operation of the recovery.
Not to take any course.
No, but if they raise the demand, that is why, my lord, it would.
In the meantime, no coercive action shall be taken against the bank shall be taken. ये item उसमें कर देना 285. 285. No coercive action shall
Be taken. Well, against the bank would mean then they will train their guns on me. No coercive action be taken, whatever that means.
No coercive action shall be taken for a period of
Covered.
12 weeks.
Yes, yes.
For a
12
period
weeks
of 12
within
weeks
that
or
period
until
you can
further
come
order, whichever is ready.
We'll have a good puja protected by an interim order if we can't succeed in the meantime. Otherwise, my lord can always my lord is taking it up that day.
Yeah, Gopal, क्या date है? Gopal,
If the return.
no, huh? 12 weeks. When do you want?
Your lordship.
No, whenever you.
Convenience.
No, Mr.
That's Mr.
Mukherjee, you know, I am ready to listen. I am here.
Lord, we Bengalis
Whenever
are
you
so
want, you tell me.
so
When do you
fond
want?
of
You want to
pujas.
do it before puja, after puja?
After puja, before puja.
All right. When do you want?
You also directed the matter after 8 weeks.
Then shall we keep it on 25th of September? I'll have time to write.
25th of September is.
Could it be the week before, 25th, my lord? Possibly, I'd be.
My lord, may I make a
All
humble
right.
prayer?
18th.
May I make a humble prayer, my lord?
Yes.
If it commends to your lordship, my lord, and if Mr. Mukherjee doesn't,
Let's finish it.
just immediately after the puja.
So let's finish it. I'll have some work.
No difficulty. Yes.
18th.
What will I do in puja?
Enjoy.
But your lordship would see the Kolkata pujas, my lord. Your lordship will see the Kolkata pujas.
That doesn't happen.
No.
Let me reserve as many as possible.
My lord must enjoy, my lord must enjoy.
At least the
Calcutta pujas, my lord will.
Only that side. After
No
you come
enjoyment
this
this side, my
side,
lord. No solicitor coming.
all
Solicitor coming
enjoyment
at
is gone.
11:30. 6 clients.
Believe me.
Tomorrow something is happening.
Believe me, Mr. Banerjee. You are better off.
Yes, I mean.
My lord, go out in camouflage and enjoy the Calcutta street food.
No, but when even if your lordship goes out in camouflage, lordship will still be under the public care. That's the whole difficulty. I mean, that is why. I mean, one of the pitfalls of going that side or the negatives is this. It's like a self-imposed incarceration always.
The puja also you don't enjoy that much anymore.
I mean, you have to enjoy, but enjoy. Let us say enjoy responsibly.
All right. So great.
18th September. On this note, hats off to your lordships and all of you. The hour after hour hearing boring people like us over and over again and making prayers.
It can be worse.
Same voice, same face, same voice.
Same face, same voice, same intonation.
You can say the same about us also.
Much also. Number 14. I speak to appear on behalf of the corporation, my lord.
Yes.
My lord, in the instant case, my lord, rent has been attached.
Yes, Mr.
My
Chair.
lordship knows in terms of the Gujarati Education Society, my lord, the hearing when to be taken place, the tenant is required to be, my lord, notified. Here, no such thing happened, my lord. I have purchased the property along with some tenant. My deed is page 15 in the year 2016. Page 15, my lord. Annexure P1.
So why you are challenging all this here? Why don't you go to the tribunal?
Tribunal, I will go, my lord. They have attached my rent. But on the one hand, they have attached rent, and tribunal says, my lord, the tax to be deposited in terms of the assessment made by the Kolkata Municipal Corporation and continued to be deposited till the disposal of the appeal. So, my lord, I have both way, my lord, this is a double jeopardy. That being the situation, my lord, here the procedure is required to be maintained by them, and then, my lord, only, my lord, the rent attachment. That is, I intend to, my lord, draw lordship attention. Lordship, kindly see a bank is there, my lord. The bank, the responsibility of payment taxes, my lord, page 45 may kindly be looked into. Page 45, agreement with the bank. 3, lessor hereby covenants with the lessee as following. After leaving 2, 3 line, my lord, 4th line, the same be levied or payable by the lessor.
Just, Mr.
True, my lord.
Chakravarti, you move too fast.
So then, my lord,
Slow,
my
please.
lord.
Yes.
Lessor. Then, my lord, in case of
Lessor
lessor,
hereby, you are reading 3A.
3A.
Yes.
And if the payment is required to be made by the lessor, then also, my lord, one judgment of the Honorable Supreme Court, Motilal Naresh Kumar, and 28% reduction to be given in such a case, my lord. That was not taken into consideration by them. Our every, my lord, doubt is there whether they have sent any notice or not. So far the tenants are concerned, no notice. So far myself is concerned, in the inspection book, lordship will find generally the signature of the assessee normally found. Signature of the assessee available. They have, my lord, we have enclosed certain, my lord, the inspection book, page 71 onwards. Here, lordship will, no signature of mine.
So the owner has not challenged this.
This one I am trying to challenge here instead of challenging, my lord, the tribunal, because double jeopardy. But I am not getting any rent.
The rent has been attached.
Yes, my lord.
Right?
Yes.
This you should pay. The rent has been attached as far as your tenant is concerned.
Yes, my lord.
Go before the tribunal.
No, my lord, kindly only, my lord, 2-3 minutes, my lord, kindly be spared, my lord. My lord, this is the inspection book. Nowhere it is written, the, my lord, the
Which page, Mr. Chakravarti?
personal liability was,
Which page?
my lord, page 71 onwards. Page 71 onwards, my lord. Lordship will find, my lord, the assessment book. By paying huge amount, I have obtained all this certified copy. Annexure P8. Nowhere written, my lord, the, kindly see, my lord, second column at the bottom, top.
Second column at the top.
Top.
Yes.
Acceptance by the RO. Lordship got it? Accepted by the RO. My lord, this portion. This portion.
Acceptance by
recorded owner. Myself is recorded owner. Signature is nil. There is a column. And then, my lord, it is written stroke PLPT, person liable to pay taxes. PLPT. So I am a person liable to pay taxes. I am the lessor. I am the liable to pay taxes. So, my lord, here no signature. Then, lordship, turn to, my lord, next few pages. That is the inspection book. But nowhere my signature is there, though there is a column. Page 72, 73, I am drawing lordship attention. Same. And decision of the hearing officer also not written over here. Now, my lord,
very good ground. Go before the tribunal.
No, my lord, the only thing is, my lord, it's a onerous. I will go there. My lord, the tenant is required to be heard before the authority. In that case, tenant discloses that the lesser responsibility, 28% to be given to the, in terms of the Motilal Naresh Kumar judgment. That is a judgment in terms of Article 141, my lord, to be, my lord, also binding all of us, my lord. No, my lord, I know, my lord, that is a judgment under Article 142. But I may be excused for, my lord, misleading this honorable court. I may be excused. Then, my lord, kindly see, what happened, my lord. Now, my lord, they have attached in State Bank. We have noticed them. They are not, Bank of Baroda, we have noticed them. They are not over here. Now, lordship, kindly see, I intend to show, my lord, the notice of attachment. That is, my lord, page, and my representation before the authority is still pending, page 63, annexure P5. My lord, the notice for rent attachment, whereas it has been found from our book of Dinesh Sharma, has failed and neglected to make payment. As a result, presently outstanding is so and so amount, 13,79,412. Then, my lord, now in terms of section 195, read with section 225, Municipal Commissioner has been pleased to attach the entire rent of bank, including the maintenance charges, service charges, so and so. Then, my lord, hence, in view of the above, you are requested to make payment of monthly rent payable by you to landlord so and so directly Kolkata Municipal Corporation, office of the collector so and so. So, my lord, our humble submission, they are at their liberty. After exhausting all other process, then only rent to be attached. I will show, my lord, the process of realization, including sending notice, including notice of demand. My lord, everywhere it has to be sent in an appropriate manner, not by, my lord, the deeming provision of that, my lord, under certificate of posting. That was decided by this honorable division bench of this honorable court. Here, my lord, I have written them a letter addressed to the, my lord, the municipal authority, page 69, prior to withdraw the notice dated so and so. So, my lord, these may kindly be considered by the appropriate authority, certain direction may kindly be given. Every other things we can clear before the authority, including the question of 28% of Motilal Naresh Kumar judgment. And, my lord, the bank and other tenant may kindly be directed to be present before the appropriate authority. And then, my lord, take a final decision. In the event, my lord, I fail, attachment will continue. My lord, this is a humble and innocuous prayer before this. But we have deposited 12 lakhs, my lord, in the month of January and February. Not that we are not paying. It is our duty, since, my lord, is a property tax, sustained with the property, troubles with the property. And, my lord, they are providing us amenity, though it is not connected with the payment of property tax. So, my lord, the innocuous prayer before the authority, my lord, our prayer for withdrawal of notice. If second thought, they are in a position, otherwise double jeopardy, I am to pay taxes, my lord. This is onerous. That is why, my lord. Monisha ki bolche? Only Gujarati Education Society judgment, Lordship knows, my lord, I have brought it. If this honorable court kindly permit me, I can hand it over.
You are ready to make the balance payment within 9 months as per the notice dated 16/12/2024.
My lord, we are challenging the question of assessment. Lordship knows, my lord, the copy of the order is required to be supplied.
I'm reading your representation.
Lordship.
I'm not making this statement.
Lordship.
This is something which you have written to the corporation.
Yes, my lord. Yes.
You are accepting it, sir. You are
Yes.
accepting everything.
Yes.
You are saying I'll make the payment, you waive my interest.
Lordship.
Nowhere you are saying that the notice has not been served, this has not been done, that has not been
Excuse,
done.
my lord, I have in the memo in my petition, I have said. And my lord,
Sir,
the
in a petition, but in your, this is a letter written by you.
So, my lord, Lordship, when they are, my lord, threatening us to put padlock, Lordship knows 225 is permissible. Attach of rent. My lord, putting padlock, it is not permissible. They are putting it regular. Attachment of rent is permissible under 225. If it is procedure was maintained or not, that is a different question altogether.
First tell me why should I interfere here? Yes, Mr. Mukherjee.
I'll just show my lord.
No, but tell me,
Certain
Mr. Mukherjee,
salient
why should this court, why they can't
Your
be
lordship would not.
really?
Your lordship has read 69.
Yes.
It was followed by page 70. 69 was followed by page 70 after around 10 days or so. And in no uncertain terms, he says this, and the petitioner becomes intelligent after meeting lawyers, files the writ petition. Your lordship would see the terms. What does he say? I am ready to make the payment of the balance. That he repeats again at page 70, that I will pay entire principal property tax amount to you within 3 months. Now, my lord, 2 extempore reference to 2 judgments have been made. One is Calcutta Gujarati, the other is Motilal Naresh Kumar. Calcutta Gujarati, on the showing of itself, it's a multi-storied building. It will not apply in case of a multi-storied building. My learned friend is having the judgment. If he kindly facilitates me. Yes. Paragraph 25 of Calcutta Gujarati, I am reading it. Taking into consideration, however, the practical difficulties particularly concerned to the multi-storied building occupied by several tenants, subtenants, occupants, a mere non-issuance or service of public and written notices to all individuals concerned who are persons primarily liable or liable would not be treated by the authorities concerned and the courts as invalidating the consolidated rate determined and apportioned on the basis on various persons regarding such buildings unless serious prejudice is found to have been caused to the persons aggrieved. Where I cannot invent prejudice from the sky. Now, my lord, he said onerous liability. That has also been answered. My lord, I'll just read paragraph.
No, but Mr. Mukherjee, he can go before the tribunal. Why should I interfere?
He can. The
Yes.
other thing is, as my learned friend has submitted, your lordship has seen 69 and 70.
Yes.
Without disturbing the present state of affairs, if your lordship can direct us, we can consider his prayer at page 69, 70 both together, and only that. He is not going to develop anything on that.
But only one.
His representation is 67, 69 and 70. He will limit himself within 69 and 70. Today he cannot develop and make out a new case before the authorities. To that extent, my lord, I can concede.
Only, my lord, the same
Not
time.
a inch more.
In terms of the taxation rule 10, my lord, they are to supply the copy of the order.
This is
My lord,
not there at all.
So far they have supplied or not to
He is
prefer appeal.
developing all these things today.
For appeal,
Sir, you have admitted.
lordship.
So let us not go on those assessment orders.
So, my lord, kindly at the same time, my lord, subject to correction, my lord, consider regularly threatening, my lord, to put padlock. And padlock incident,
Submission from the bar.
padlock incident are going on, my lord. Every day, lordship facing such cases,
From
my
the
lord.
bar.
Not in the four corner of the provision of the statute. Lordship, that representation may kindly be considered, my lord, subject to the
To that
lordship.
extent. Only I will limit to the lines in the representation.
And here also my learned friend, my lord, indicated that I intend to pay, my lord, the principal amount. Here in the last paragraph, my lord, penultimate paragraph, my lord, that I will pay the entire principal amount within 3 months as soon as possible hereby. Once again, request you to withdraw the all charges, penalty, interest, and by you, and I will pay the entire property tax as committed above. My lord, interest and penalty are huge, my lord. And on the one hand, they are calculating. On the other hand, my lord, amount deposited with the credit of corporation, they have decided, they have inserted a particular provision not to pay, my lord, the interest. Not to pay interest. In one-way traffic, my lord.
See, they can consider it if you want
Lordship,
to be
lordship,
considered.
lordship,
You want to,
lordship.
you want this court to relegate you to the tribunal, it can do that.
No, my lord,
What
not
do you want?
relegation, my lord. The difficulty is payment of tax, my lord. Relegate to the Kolkata Municipal Corporation, my lord, subject to the lordship pleasure.
As I have submitted.
The petitioner in the present writ petition is challenging the annual value determination carried out by the respondent municipality, Goa, premises number 2, Hem Chandra Naskar Road, Police Station, Beliagata, Calcutta, with effect from fourth quarter of 2016 to first quarter of 2017. Since learned counsel for the petitioner submits that he has made a representation dated 27/1/2025 and 6/2/2025 before the respondent municipality for considering the waiver and considering the interest and penalty which has been raised to be waived off. Full stop. Though the petitioner has admitted the liability of the property tax. Full stop. Learned counsel for the respondent corporation states that they are ready and willing to decide petitioner's representation dated so and so only to the extent of deciding his penalty and interest on the assessment, on the property tax, on the assessed property tax. Full stop. Learned counsel for the petitioner submits that he shall be satisfied if his representation is decided only to the limited extent which has been enumerated in the representation dated 27/1/2025 and 6/2/2025.
And the respondent number 3 or 4, my lord, 2 respondents are there, including Calcutta Municipal Commissioner.
Yes.
3 or 4, anyone?
In view of the submissions made by the counsel for the parties,
The chief manager revenue.
this
Not
court
party.
directs the
Oh, yes, but chief manager. But
Three.
yes.
Unless
the
your
respondent
lordship
number
send it to the three.
three revenue. Respondent number 3 to decide. Assessor and collector or 3?
Not chief manager revenue north.
Respondent number 3,
That's respondent number 3.
Chief Manager Revenue North, to decide petitioner's representation dated so and so 27/1/2025 and 6/2/2025 to the limited extent as it has been stated in the representation. Full stop.
And within a stipulated period.
The petitioner will be satisfied if the same is decided within the time bound manner. Okay, ऊपर कर देना within a time bound manner. In view of so and so, this the court directs the respondent number 3 to decide the petitioner's representation dated so and so within a period of
4 weeks.
Within a period of 4 weeks, strictly in accordance with law, after affording an opportunity of personal hearing to the petitioner. There's no respondent, private respondent.
Yes, my lord. The bank authority is there.
I cannot enforce them. It's up to their prerogative whether they come or not.
As well as you have to give notice to them.
Yes.
As well as the private respondents. Full stop. By way of a speaking order. With the above direction, the presented petition is disposed of.
Great.
Deep lock.
Don't you hold these camps where the interest and liabilities and other things are waived off?
Interest and penalty, it arises from section 270.
No, that I know. Like in Delhi, we generally hold
In
these.
the same line.
We hold these
But
camps.
Delhi came
Where you
first.
come, you make your payment and interest and penalties waived off.
Waiver schemes.
After
Sometimes
every
Waiver schemes are there.
Sometimes they introduced, my lord, not always.
Waiver scheme, even today also there is a waiver, but now it is graded waiver. Depending upon how many years the dues are, they will give you waiver considering that part. Previously, it was flat, 50% waiver of tax.
To please big houses, my lord, the 100%.
My lord, my learned friend should not make such wavered comments in the court. It's absolutely wavered comment.
Deeply applied.
Grateful.
I am appearing on behalf of the petitioner, Your Lordship.
Yes.
This writ petition has been filed against the KAMES, Kolkata Municipal Corporation, due to its inaction against a complaint I filed with regard to unauthorized construction, Your Lordship. The unauthorized construction is evident is expressly evident from the pictures which I have annexed, because, Your Lordship, there is a common boundary wall. Now they have put up posts on the boundary wall from my side and covered that portion. Kindly comes to page 18 and 19. Once. Your Lordship kindly comes to 19. The bottom picture, Your Lordship kindly sees the posts which have been put up. It is on the boundary wall between my premises and the neighboring adjacent premises. It is on our side of the boundary wall, covered up the entire open space. We have written to the executive engineer, Your Lordship. No steps have yet been taken. The construction over there is still going on.
Mr. Das, you are appearing.
My lord, right now I actually received the brief. Right now. My lord, here, my lord, no inspection report. Right now,
May I file the affidavit of service? It was served.
Lord, just kindly take page 17. Initially, that is, my lord. Lord, just kindly take page 17.
Decide the representation, Mr. Das.
Your Lord,
They make representation, nothing is done.
The inspection was done. The inspection was carried on.
You are private respondent.
Private respondent and the owner. The inspection was carried on. These are the only construction. If this can be termed as construction, these are bamboos and
but your
that is for the corporation to look
The corporation came, inspected.
May I
found
be?
no illegal construction, went back.
Your Lordship, it is not true. It is evident from the picture. On the boundary wall, on our side of the premises,
yes,
the structure is coming in and there is no illegal construction. That is quite surprising. Only, Your Lordship, I have not been provided with the inspection report till date, Your Lordship, and I do not see any action having been taken.
So I'll send you to the corporation, go and they'll decide your representation.
Your Lordship kindly directs them to serve a copy of the inspection report and kindly sends. Because we haven't, and Your Lordship, if that construction is still going on, no order has been passed by the KMC for stoppage of such erection, Your Lordship. The construction is not yet complete and they haven't.
Construction, my lord, over the phone right now I received the brief. They told me that one bamboo stick and that
Your Lordship, this.
my lord, somehow written that is try to construct.
Your
Right
Lordship,
now,
I fail to understand how these iron bars can be called bamboo sticks.
bamboo or iron bar and plastic set.
Bamboo or iron bar.
This is construction. See the picture.
My lord, I am appearing on behalf of state, my lord.
State has nothing to do.
My lord,
Yes.
they made party in Narkelanga police station, my lord. They inquired the matter. They have stated there is space to ingress and egress.
You have nothing to do, madam. For the corporation to decide whether there's space or
Bring the
not.
matter back to the corporation for regarding inspection they have done on.
Your Lordship, may I only pray this, Your Lordship?
You want an end to this or you want to continue with this?
No, I want an end to this, Your Lordship. I want an end.
So
I
go
don't want
before
to
the
drag the
corporation, at least they'll consider it. You want, I'll
Yes,
ask
yes,
them to
yes.
file their affidavit, 4 weeks, 2 weeks.
No,
You
no,
want
no,
that?
Your Lordship, I'm not
What
seeking
do you
for
want?
that. Your Lordship kindly directs them to take action. What I was only beseeching, in the meantime, if Your Lordship keeps it pending so that Your Lordship can see whether they at all have taken any action.
No,
That's
I'm disposing it off.
very good.
If I'll keep it pending, I'll keep it. You
No,
want,
Your
I can
Lordship.
keep it pending. You want me to keep it pending? I'll keep it pending.
No, in the meantime, if they take action, only for that purpose, no, nothing else, Your
Cut
Lordship.
short the litigation.
And Your Lordship kindly directs them to provide an inspection report. Which
They'll
might,
give you a hearing. Get the inspection report. They'll give you a hearing also.
yes, Your Lordship, the prayers have.
Take down. Petitioner. The petitioner has preferred the present writ petition being agreed by the inaction of the respondent municipality not taking any action
May I take your lordship's leave?
for stopping the unauthorized construction allegedly to be raised at premises number 138/1 APC Road, District, Calcutta, on behalf of the private respondents. Private respondent number
5.
On behalf of private respondent number 5, full stop. It is the case of the petitioner that he is the owner of the premises having.
Co-owner, my lord. I am one of the co-owner. I am one of the co-owner.
No, which premises? Next, his next door premises, right?
Yes.
Yes. He is the owner of premises having holding number 18 Karbala Tank Lane, comma, Burtola, Calcutta, full stop. It is stated by the learned counsel of the petitioner that in his neighborhood, comma, at premises number 138/1, comma, APC Road, comma, Calcutta, comma, the private respondent is carrying out illegal and unauthorized construction by raising tin shed factory, full stop. Learned counsel for the private respondent number 5 states that he has not raised any illegal and unauthorized construction, but has only put bamboo. What bamboo?
Bamboo and tarpaulin, my lord.
Bamboo.
To save himself from the rain.
Bamboo and.
Over his part of the property.
Turmoil, this turpine. What do you call it?
Tarpaulin. Tarpaulin. Tarpaulin.
To avoid the rainy season. Full stop.
within his part of the property, my lord. This is my submission.
Within his property. Full stop. Learned counsel for the petitioner states that he has made a representation dated 24th February 2025 to the corporation, but the same has not been acted upon. Full stop. Learned counsel for the respondent corporation states that they are ready and willing to decide petitioner's representation dated 24th February 2025. Full stop. Learned counsel for the petitioner states that he shall be satisfied if the same is decided within a time-bound manner. Full stop. In view of the submissions made by the counsel for the parties, this court directs respondent number, respondent number 4 to decide petitioner's representation dated 24th February.
4, Your Lordship.
4, yes, 24th February 2025 within a period of 8 weeks. Within a period of 8 weeks, comma, strictly in accordance with law, comma, after affording an opportunity of personal hearing to the petitioner as well as the private respondent, comma, by way of a speaking order, full stop. With the above direction, the present writ petition is disposed of. No affidavits have been exchanged, none of the contention.
My lord, they made Maniktala police station, my lord, it is under the Narkeldanga police station.
Your lordship, may I only be?
That's all right, give your appearance.
Only one
Yes.
more thing, your lordship. Your lordship, if your lordship would be kind enough to direct them to conduct an inspection in presence of both the parties before the hearing, because I don't know what
Without
report
inspection,
happened.
without
They will do
inspection,
whatever
they
they
cannot
want.
hear it.
Just apprise your lordship that an inspection has taken place where it does not show any
They
unauthorized.
will do whatever they have to do.
Because the only reason being they will, in the hearing, they will say that we have conducted an inspection, there is nothing, which my learned friend just pointed out. The
If they do that, you come back here.
Item number 16, I appear for the petitioner in this matter. So there is an allegation of illegal and unauthorized construction. It's a G+1 construction which has been made, and Lord, I have made a representation which Lordship will find at page 19 of my writ petition. Because this representation was made on 12th of February 2025, Lord, no action has been taken by the Kolkata Municipal Corporation. And no inspection has been carried out even. That is my instruction. If your Lordship, Lord, kindly comes to page 19, that is my representation. Page 18, Lord, I have annexed the photograph of the construction.
Page?
Page 18 is a photograph of the construction. And Lord, page 19, Lord, I made the representation.
Who are you?
But I am, Lord, one of the co-sharers of the property. Lord, there is a suit which is pending. And Lord, there is an order of injunction which is subsisting till today, Lord. I have annexed the order of the injunction. Lord, your Lordship, Lord, kindly comes to page 73. This structure has
like an old property.
Well,
this looks like an old property on page 18.
No,
What is
there
the
have been
construction?
subsequent construction.
Where is the subsequent construction, sir? On this picture, there's no construction.
No, but this.
Why are you showing this picture for what? These are all private disputes. You come here to settle your private disputes.
No, Lord, for settling the private dispute, Lord, there is a suit pending.
Yes.
Before the
So
learned
what is
court.
there in this picture on page 18?
This is the picture of the construction, Lord, which doesn't have any sanction plan, Lord.
The entire construction is
without any sanction plan.
Without sanction plan?
Without sanction plan.
Where do you stay?
Well, I have stated, Lord, that is where page 19, if your Lordship comes. Lord.
Where do you stay? Do you stay in this property?
Well,
do you stay in this property?
No, I do not stay. I am staying in the vicinity.
So what is the dispute between you and him? The civil dispute.
Civil dispute. That civil. I have annexed the documents, Lord. There isn't.
What I'm asking. What is the dispute?
Dispute is there is a suit of partition, Lord, which is pending. The property, Lord, where the construction has come up. I allege that the property also belongs to me.
Oh, you're saying this property belongs to you?
Yes, yes. That also belongs to. I am one of the co-sharers, Lord. And Lord, during the subsistence of the order of the injunction, Lord, this construction has come up.
This doesn't look like a new construction, sir. When did you get the stay? Show me from the document.
Lordship's query is, Lord, this is a.
When did you get the injunction? Where's
Yes,
the
Lord,
injunction
the
order?
injunction, Lord, was passed. If your Lordship, Lord, kindly comes to page 73. 73 is the starting. The relevant part is at 75. But I am only
2009.
2009, yes. And this injunction is subsisting, the suit is pending.
The property came up overnight.
No, it came up recently, beloved.
Recently,
The
this is
ground
a
floor.
recent property.
No, the ground floor was there. They have made subsequent construction, and the entire construction is illegal. It doesn't have any building plan sanctioned by the corporation. That is my contention.
Petitions filed just to harass. We'll have it after 4 weeks. Keep it after 4 weeks. Just 1 second. Show it to me. Just I'll dispose it off on. Mr. You have what is your instruction, Mr. Das? What is your instruction?
My lord, regarding this matter, my lord, I have to yet to take the instruction also because this is also today I have received the instruction. And my lord, your lordship kindly see the paragraph 2, that is G, but that is G+1 was there. His complaint is above and above the G+1 construction has been done.
Over and above?
Above the G+1, that is paragraph 2. If you
had filed a writ petition earlier.
Yes.
Where is that?
Earlier.
No, not earlier, my lord. This is the representation that I have made. Page 19, your lordship will.
Page 83.
Yes, that is in connection with a separate writ petition that I have filed, but I have also annexed.
Same cause of action.
Same cause of action.
You'll file another.
No. In that writ petition, my lord, this particular petitioner was not made a party. My lord.
All right, take down. The petitioner has preferred the present writ petition, being aggrieved by the inaction on part of the respondent municipality in failing to take appropriate steps to stop or demolish the alleged unauthorized construction being carried out at T157, T-157, Murray Road, PS Raja Bagan, Calcutta, full stop. On perusal of the record, it transpires the petitioner had already instituted another writ petition being WPA number 7958 of 2023, raising identical grievance in respect of unauthorized construction at the same premises. Full stop. In order dated 24/11/2023, passed by this court therein, it was noted that the partial demolition of the structure has already been effected, full stop. However, in view of the presence of the occupants on the lower 2 floors, the remaining demolition was directed to be undertaken subsequent to the vacation of the premises of the aforesaid tenants, aforesaid residents, residents. The aforesaid writ petition continues to remain pending for adjudication before this court, full stop. In the aforesaid circumstances, this court is not inclined to invoke its discretionary jurisdiction under Article 226 of the Constitution of India, since the petitioner has already instituted another writ petition WPA number 7958 of 2023, and the same is pending adjudication before this court. This court finds that the present writ petition has been filed without any merit, and the same is dismissed with cost of 5,000.
But may I assist your lordship, Lord? That is in respect of different buildings, Lord, and that instant writ petitioner was not made a party in that writ petition.
Sir, the building is the same. Come to page 83. Page 83.
No,
No, the premises number is same 157, but in that premises number there are several buildings. That is why, Lord, there are pictures.
Challenge it.
Next.
Thank you, bhai. My lord, I am appearing for the respondent number 11.
I appear for the respondent numbers 15 and 16.
My lord, I appear for the petitioner.
I am appeared for the
My
respondent.
lord, very innocuous.
Commission.
My lord, very innocuous prayer, my lord.
Yes,
My
Mr.
lord,
Trivedi.
my lord, innocuous prayer, my lord. I am a resident of this particular building in question, which is 26 Jawaharlal Nehru Road. Now, my lord, certain construction was being undertaken. Recently, I have been informed by my learned friend who is appearing for the Heritage Department that it is not, even now, it is not a heritage property, but admittedly, it's a property which is more than 100 years old now. Now, my lord, unabated construction was going on, for which, according to my understanding, permission or sanction is required because it is not a repair as permissible under Rule 3 of the building rules. Now, my lord, for that, I made several representations. One representation was initially made when the construction started in the month of October 2024. Subsequently, the construction went on unabated. Certain structural changes were made in the rooms. Now, my lord, subsequently, I again made a representation, and now, then after that, I came before your lordships. Now, my lord, if my lord kindly takes up the photographs. Now, my lord, what I understand, because I'm a resident of that building, the construction work has already been completed. But as far as section 400 is concerned, lordship, if the corporation comes and says, my lord, there was a sanction, then I'm out of this court.
Page 36.
My lord, 31, it starts, my lord, pictures, my lord. Page 31, 32, stacking of bricks. Then, lordship, this is the condition of the building. Now, my lord, this is the page 30. Then, lordship will kindly see page 35, which shows, my lord, how the construction is. For this, under in my understanding of the law, my lord, a permission under section 390 of the Kolkata Municipal Corporation Act is required because there is substantial addition and alteration and changing of structure. Now, my lord, all this was going on, and my lord, I had made a representation that is at lordship.
You are a neighbor? What are you?
My lord, I'm staying in the same building.
Same building.
Yes, lordship. I've stated that in the first paragraph.
Looks like strengthening of the building.
My lord. My lord, it is not strengthening of the building, my lord. My lord, therefore, it is actually, there are several flats in that particular building. The building belongs to Murshidabad Estate, which is governed by the Murshidabad Act. Now, my lord, it is under the aegis of the state of West Bengal. Now, my lord, the people who are residing there are people who are either working in certain government offices and other tenants like me who are there, and they have started proceedings against us under the Murshidabad Act. That is a different issue altogether. Now, my lord, I am admittedly residing there. Now, my lord, so I am within my right to make a complaint before the corporation, and corporation has a duty, my lord, to at least reply to my complaint if a sanction is there.
Yes.
Then, my lord, I am out of I will not unnecessarily come before your lordship.
Well, Lord,
So, my lord,
one thing.
Sir, apni kya na boli?
I like him very
Just
much.
let him finish. Yes.
All right.
A very small case. I would not go even further, my lord. My lord, at page 26, my lord, my first representation is there, my lord. Case is very simple and small, my lord. I can go on showing so many laws and books which my lord knows, hearing so many matters on the Kolkata Municipal Corporation. Now, my lord, it is for them, corporation, to say whether there was any sanction or not. Because they are the authorities, my lord. I cannot.
Who's appearing for the corporation?
Sorry to interrupt, my lord. Sorry to interrupt.
Yes,
I'm begging one
Mr. Banerjee.
My lord, yesterday I have heard, I was present here. My lord told our junior lawyers, look, I can tell you, when you will accept it, you must think whether it has come to you with a clean hand or not. My lord, not only clean hand, unclean hand and clean mind. Now, observation of Justice Arijit Paswat. This gentleman, not he, I like him very much. His client, I just asked, my lord very rightly said, who are you? What is his status? Well, in all those buildings belongs to Murshidabad Estate, Nawab properties. Ultimately, by act that was acquired, my lord, then we are running all these things. He is, my lord, absolutely outsider. Somehow or other, he entered into that. And he claiming that I am occupier. Mere occupier is not true, because all those building, my lord, is misusing this way. Suppose X was inducted. X, by taking some money with the knowledge and consent of the us, inducted Y, then Y said in this way it is going on. We initiated a proceeding against him. Very nicely, he said, there is another proceeding. I don't mind all this. No, he should. An eviction order is passed against him for these reasons. He's an unauthorized occupant. Now, my lord, very unfortunate, is I pay for an appeal. So, whole case is this. Because he's under pressure, he's getting, well, these flats are always being used by the judicial department because they are actually enjoying this. And my friend probably appearing for them, my lord, the judicial department and those who are working in your lordship's court and others, they are provided with the flat, not the permanent. My instruction is this, because I am the authority. One person is not making any construction. Other person, he stopped it. Now, first thing, my friend, he'll say whether it is a heritage building or not. Secondly, my lord, who are you? I'm asking. First, you show to my lord that, well, you have a substantive legal right. You have come with a clean hand and clean mind. You suppress this fact that you have suffered a degree. That has not been disclosed. Now, casually says, he knows we will take the, well, another proceeding was started, so I'm not concerned. You are very much concerned. I am also concerned. And you have to answer to my lord, why you are moving this application. Who are you? First, you satisfy the court. You have come with a clean hand and clean mind. You have no right to challenge.
Yes, yes, Mr. Ghosh.
My lord, report is not with me, but I have got just information, my lord. It's one of the proceeding has been initiated on inspection, and hearing date has been fixed. But somewhere.
That is what I was on. Corporation will come because, my lord, I don't want to join issues with my learned respected friend.
But corporation has already initiated proceedings.
They were at least, my lord, even if I am a citizen of India,
They would have only done it after you have filed it.
my lord, if maybe, my lord, so let them come up with the report, my lord, and say, my lord,
Case, my lord, T133/7 of 24/25. Demolition case has already initiated. Once the hearing took place on 19th of June 2025, and further, my lord, let it be also
given a chance of, my lord, I should
in its usual course.
File your report, Mr. Whom?
private response.
Private response. You are carrying out the unauthorized construction.
Alteration on taking permission from the estate manager. First submission. First, who is the petitioner? Kindly ask him to produce.
He said he's a tenant.
Kindly ask him to produce.
I will produce everything.
No.
And I am within my right.
Why did you not produce?
This sort of a letter. Kindly see this allotment in my favor.
Yes. So let there be allotment. I am fighting an appeal. And I am a maybe.
This is another allotment in my favor. What I was respectfully submitting, sir, in support of his tenancy, he has only appended one electricity bill as annexure P1 and another document.
And he has suppressed all these things.
He has not disclosed these papers.
My lord, I will.
Not from anything else. My lord, he is a meddlesome interloper, if I may use this word with caution, my lord. He is trying to say things on incorrect assessment of his facts. And my lord, I have got permission from Mr. Banerjee's client to make, my lord, certain modifications in the room, nothing else. I am not making any construction.
You can go to the corporation. They will.
So much, whatever hearing, June, the date was fixed. I attended the hearing.
Very good.
What satisfied?
Let
I
them
have
file
made
the
a complaint.
report.
They should give me a copy, my lord.
Let them file a report.
Let them file a report, my lord.
As the heritage building is concerned.
My lord,
not a heritage
my lord, even
West Bengal Heritage Commission. But my learned friend's client made an oath. Paragraph 4 of the petition. That building is declared as a heritage building under the West Bengal Heritage Commission. Well, this statement is absolutely false.
This should be dismissed.
Well, this thing is not under the notified list of Heritage Commission. As such, the Heritage Commission does not have any relation with this.
Let them be expunged. Lordship will kindly.
How can be
no.
How can be expunged?
My lord, I am not shying away. My lord, I am not shying away, and I'm still championing for the cause of my client, and I have enough materials to that. My lord will kindly not take me amiss. this property, my lord, if it is not a heritage property, my lord, if we were always, my client was always under an impression who is there. Now, my lord, first let me just, because these things have come out about my locus. My lord, wasting my lord's time to 30 seconds only as my clock starts now.
No, you can take.
No, my lord. Because this is just because I am because certain things have been made with regard to my locus, my lord. Two wrongs will not make one right. Corporation has said that they have initiated proceedings. So under the KMC, whatever was done by the clients of my learned friends was illegal within the parameters of Kolkata Municipal Corporation Act. That ends my issue. And now, my lord, I am entitled, if they're taken any action, if I am aggrieved by that, I have got my remedies, not in this writ petition. Now, if other things now, my lord, as far as I am concerned, I am suffering a degree under section 9 of the Murshidabad Act. I have preferred an appeal.
So what?
And that appeal is pending, and I am enjoying a stay from a competent appellate court. And the appeal is being heard. Till the time I am evicted by due process of law, I am residing therein. I have all right under the sun to assail any illegal activities of construction. My locus cannot be challenged. Now, my lord, another point, my lord. Anybody, Kolkata Municipal Corporation is a statutory authority which is duty bound. Law should prevail for everybody. Just someone goes to the judicial department and he makes an illegal construction, and what right does the estate manager has? He has become the commissioner, corporation commissioner. Now, my lord, when you have the weakest case, my lord, you come on technicalities. And technicalities is the handmaid of justice. That's what little law which I have learned. Now, my lord, in my respectful submission here, corporation submission stares at the face that illegality has been committed. Now, my lord, so let them file a report, my lord.
Just
Let's
one,
let the
just
better
one,
about my
just half a minute, half a minute. No, just half a minute. Is it a public interest litigation?
I
Law is very clear. If you come before the court of law, you must show that you have got a substantive legal right.
Legal right. If appeal is pending, I don't have a legal right, my lord. I have learned law from my learned friend, my lord. I should not make any such.
With greatest of respect.
Yes,
But
Mr.
whatever submissions are being made from the bar. These pleadings are not there in
Let
any of
them
the
do it. This whole fight, I don't, Mr. Bhattacharya. You have been given a hearing. You are satisfied that you are not carrying. We are only concerned. We are only concerned about Mr. Bhattacharya. We are only concerned about the corporation. We are not concerned about anybody's else's client.
But my lord, someone who is coming to your lordship's court has to at least plead certain basic facts in the writ petition in order to maintain a writ petition. My lord,
So he is still a tenant. That's what he has said. Eviction order has been passed, but he is still there.
And I put this question entirely to myself.
All right.
With greatest of respect.
Yes.
Sentence more I'll stop. Not the paragraph 2, and in support of paragraph 2, what is the document?
Yes.
Paragraph 2 is.
We will take Mr. Trivedi's statement at the bar.
2 and the document in support of paragraph 2 is an electricity bill.
Yes.
That does not make someone, my lord, owner or occupier.
He is occupied. That's what.
My
That's
lord,
the statement he's
let them file a report. Let me, if my learned friend is making submission from the bar on instruction, I will come and I will prove it that my appeal is pending and I'm enjoying a stay. My learned friend must have been,
I'm not denying. I'm not denying.
Everything else.
Where is the issue at all?
That's okay. The petitioner, take that. The petitioner in the present writ petition is aggrieved. Is aggrieved by the inaction on the part of the respondent municipality in not taking any steps for stopping/demolishing the unauthorized construction carried out at premises number 26, Jawaharlal Nehru Road. This is Calcutta only, right?
Lordship,
Kolkata, at the instance of private respondent number 15 and 16 in collusion with respondent number 11 to 14. It is the case of the petitioner that the above mentioned premises is a property which belongs to Murshidabad state and is governed by Murshidabad State Management Act, full stop. The building is managed by respondent number 10, full stop.
11.
respond number 11. Full stop. He further states that the private respond number 15 and 16 are occupants of room number 5B on the 5th floor and room number 27 on the 2nd floor, respectively. Full stop. Respond number 15 and 16, without having any permission from the Calcutta Municipal Corporation, is carrying out unauthorized construction. Learned counsel for the petitioner states that he has made several representations to the respondent corporation, but the same has not been acted upon. Full stop. Learned counsel appearing for the. Should I record your submissions also?
Yes. Something is recorded, my lord. At least for my junior friend, my lord, otherwise days have changed. My lord, days is gone.
Learned counsel for the private respondent. You appear for the private respondent.
No.
You are appearing for the state.
Murshidabad state.
Murshidabad state. Learned
11.
counsel for the Murshidabad. Learned senior counsel, Mr. Banerjee, who appears for the respondent number 11.
11.
Respondent number 11 states that the petitioner is having no locus to file the present writ petition. Full stop. The same stand is taken by the counsel for the private respondent number 15 and 16, Mr. Visurup Bhattacharya, who states that the petitioner has no locus to file the present writ petition since he is no longer a tenant, and in terms of an order passed by the civil court in an eviction proceeding, the petitioner has been an eviction order has been passed against the petitioner. Full stop. Learned counsel for the petitioner refutes the said contention and states that he is a lawful tenant in the property, and the eviction order has been assailed before the concerned court, and a stay has been procured in his favor. Full stop. He still resides at the above mentioned property. Full stop. Without getting into the dispute, in the civil dispute between the parties, this court is of the prima facie view that in case any illegal or unauthorized construction is being carried out, it is the statutory duty of the respondent corporation to ensure that no illegal or unauthorized construction is carried out in the above said property without having requisite permissible permission from the respondent corporation. Full stop. Learned counsel for the respondent corporation, Mr. Alok Ghosh, states that necessary action is already underway, and a hearing has been granted to the learned counsel for the private respondent number 15 and 16. Though
Only one. 16.
Private respondent
16
number 6. Private respondent number 16. Full stop. Though he seeks and is granted. How much time, Mr. Ghosh?
16 has not report 2 weeks.
Seeks and is granted 2 weeks time to put forth the facts by way of a report in the form of an affidavit within a period of 2 weeks, exception to the same if any within 1 week thereafter, list after 4 weeks. Learned, yes. वहाँ ऊपर जहाँ respondents डाला ना, वहाँ एक और sentence डालना. Learned counsel for the respondent number 8, the heritage, the chairman West Bengal Heritage Heritage Commission has taken a strong exception to a false statement made by the petitioner in para 4, wherein he has stated that the said property is a heritage building. Learned counsel for the petitioner, on behalf of his client, tenders an unconditional apology for the said statement.
My lord will kindly see, it still shows in the site as a heritage property.
In the site?
Yes, my lord.
All right, nothing.
Apna this side, sir.
26.
26 all. Lord, I was really
There are
perturbed.
two provisions. One is the Heritage Commission Act, one is the Corporation
Whatever
Act.
it is.
My lord,
425.
26, my lord, will see.
Is not under the West Bengal Commission, West Bengal.
My lord,
That's all right. That's okay, sir.
my lord, then, my lord, actually, it can be a bona fide mistake because it is showing in we go by the website. Now, there is a differentiation between two.
My lord, there is a two provision. One
And for that, my lord,
94.
my lord, I am not on that. If it is not, my lord, let them be expunged. But my lord, why, how, I had a bona fide,
Just a minute. This is the property number is
26.
20.
My lord, will kindly see on the side.
This is Jawaharlal Nehru Road, right?
Not sure.
Uh, Mr. Trivedi is 30A, 30B, 30C.
26 is, my lord, what we could see, my lord. 26, my lord, on top, my lord, I suppose it, my junior.
Oh, yes, yes.
26, my lord.
I'm not recording it. What is the point of
Well, only one mistake has
Just-
gone down in the order.
Yes.
So, my lord, now, my lord, they,
Instructions I am submitting.
Kaal ke nahi aa
Not the respondent number 16, it is the respondent number 15 who has attended the hearing, not 16.
You only said.
I will just mixed up.
ये respond number 15 has been granted hearing. जहाँ 16 लिखा है ना, hearing 15 है. I recorded 15. You said 16.
And there was
15.
no notice for 16.
That's all. I'm
Very great.
Therefore, my lord, I apologize, my lord, but I
no.
normally.
You don't have to. This is not a wrong statement at all.
So, my lord, I was taken aback, my lord.
Just
It is a heritage building. If they are putting it on their side, it is a heritage.
So, my lord,
Apart
now,
from that, I just reminded your lordship, sometimes clients are coming. Sir, this is the fact. I cannot deny the stand of Mr. Trivedi. I like him very much. I had a privilege to
No,
take
but this kind of a, sir, this is a heritage building. If it is not in your West Bengal, doesn't mean it is not a heritage building, sir. Please have a understanding of heritage building, please.
This building to be declared under the provision of West Bengal Heritage Commission.
Sir,
2001.
there are two kinds of heritage buildings. One declared by the central government, one declared by the state also. It is, and everywhere is the same law.
In corporate, there is a
Maybe under your whatever it is, West Bengal Heritage Commission, you have not declared it, but the central government also declares heritage buildings. There are a lot of properties which are heritage building declared by the central government, like Humayun Tomb, Taj Mahal. There are a lot of buildings, maybe like, I don't know here, there are some hotels which are heritage. Maybe declared by the state of West Bengal.
We have also declared Kolkata Municipal Corporation also
As a
declared.
heritage.
When the reports come, they submit, my lord, regarding this particular building, my lord, also, my lord, we report, my lord, to us, my lord, regarding heritage status.
My lord, I am appearing, my lord. It hurts when a learned counsel, without going through the site and the volume which is there on site, makes an aspersion against a counsel, my lord.
Mr. Trivedi.
No, it is not as person is the council.
That we have said that.
Suppose.
I also feel bad, Mr. Trivedi.
My lord, I take
wrong.
back my words.
So,
I
and ask us, sir, this is the position. Normally, we work on the
Yes,
position.
my lord, because it is shown there.
Which is on record, must be on record. Therefore,
It is on record.
Now,
It's a corporation is.
no, all right, now all quotes are those and font.
আপনি আমাকে বলছেন।
No, Mr. Trivedi.
I apologize, my lord.
It's all right.
Sometimes, my lord, exuberance overtakes, my lord.
No, you feel bad. I can totally relate to that. If a wrong statement is made, you feel bad about it.
Kindly for 61 to 64, my lord. I notice upon the learned advocate appearing for the respondent. Petitioner.
I also mentioned this matter. I am in 62. I mentioned in the morning.
I am for 64, my lord. Petitioner, my lord. Interim order, my lord, extended lastly, my lord, by Justice, my lord, Chanda on 19th day of March 25 for 4 months, which is expiring this week, my lord.
This is Calcutta serological.
Yes, my lord.
4 matters
Two,
together.
my lord, 64, 61 to 64.
Similar matters.
My lord, many times it extend or the interim order extended.
Yeah.
Kindly extend for the further period of 4 months. We are ready for hearing, my lord. By affidavit exchange between the parties, my lord.
But the corporation has used the affidavit yesterday only. It has been served. I am praying for 2 weeks time.
Who's appearing for the corporation?
In one matter, I am appearing.
In my matter, Mr. Das is appearing.
Mr. Das. You are appearing in all the other matters?
All three matters, all matter is Mr. Ghosh.
My lord, in one matter, I am appearing for the corporation. I have my opposition with me. May I file it? Item number 63.
Let's take one by one. 61. Wait, sir. I'm asking 61.
I am for the corporation.
Who's in 61?
এই তো আপনি আছেন তো corporation.
Who's for the petitioner in 61? They're all connected.
Yes, they are all connected.
Relating to the 1 or 2 buildings in the same cause of
3 buildings in a row, 9, 10, 11.
So the first one, 61. Who's there?
Saurabhdar appeared lastly.
Your order, when was the stay order passed?
The order, my lord.
In 2020.
Expired long back.
Long back it has expired. Why?
Lastly, it was extended in March, my lord, for 4 months.
Just a minute. Why everybody speaks together? Yes.
19th March, when your lordship was not sitting, the urgent determination with Justice Chanda was there, and
Yes.
his lordship was pleased to extend for 4 months, and that is expiring on 18th. So far, my knowledge goes.
Order record আছে order তুলেছো? Well, I cannot exactly remember about that matter, but I find that the document which has been handed over to me, that was of 18 December 2024. That order must be recorded in the order sheet. Order sheet, that order sheet.
This relates to what? Property tax or unauthorized construction?
No, but this
No, no,
is
but the
old building, my lord, reconstruction, all these points are there.
dangerous and liability.
সেটা এখানে হয়েছিল extension, তার আগে হয়েছিল।
So in item 61, you are appearing for the corporation? You are appearing. You have filed your affidavit.
My lord, that is served upon him. Served already upon
No,
him.
I'm in 62. Affidavit has been served upon me by corporation. I'm praying for extension of time to file reply.
All right. In 61, just put it none for the petitioner. Mr. Das appears for the respondent corporation and states that the affidavit has already been filed, and the same is, you have already filed.
Yeah, that is not there, my lord. Again, this is mentioning, I can file today. Half an hour is needed because my lord in chamber that
In 61, you have not filed it.
I have already affirmed that it will serve the copy upon the petitioner, but today before your lordship, the copy of the affidavit is not lying with me right now, your lordship. Within half an hour, I will. Your lordship can write because I will.
Then give
I will.
Mr. Das, respondent corporation, and has filed his affidavit. The same is taken on record. Please give. The same is taken on record. Full stop. Exception, if any, within 2 weeks thereafter. Full stop. This is for item 61. 62.
62, my lord, I am for the petitioner. I
Mr.
have received the
So-
affidavit in opposition.
So and so
In 2 weeks'
appears.
time, praying for 2 weeks time to file a reply.
Your affidavit is here in this one?
That also I will file.
All right. Take down. Same. Mr. Das
and I am
appears for the corporation and states that the affidavit is taken on record. Mr. So and so appears and states that seeks and is granted 2 weeks time to file his reply to the same.
And the interim order may be extended. For
Interim order granted so and so is extended further for a period of to file his reply to the affidavit in opposition. All right. Give me the file interim order 62. Interim order granted earlier, which has been extended from time to time, is extended further for a period of Mr. Das, 2 months?
My lord, in this matter, 62
2 months.
Here, my lord.
62.
62.
My lord.
2 months.
My lord.
First maybe 2 months. Interim order granted earlier 2 months. This also 2 months. Item 63.
My lord, I am for the corporation, my lord. May I file my opposition?
Yes. Learned counsel for the corporation files their affidavit in opposition. The same is taken on record. Who's in item 63 petitioner? Reply if any within 2 weeks thereafter. None for the petitioner. Reply if any within 2 weeks thereafter. Stop. List interim order granted earlier, by same order, interim order. Further 2 months. This is 63. 64.
Mr. Ghosh is my leader in this matter, lord.
64 months.
64, Mr. Ghosh.
I'm told the original the affidavit is with him.
I will file.
You'll give it today only, right?
My lord,
Yes.
today.
Same. Mr. Ghosh appears for the respondent corporation and has filed his affidavit in opposition. Same is taken on record.
My lord, prefer one GA, my lord.
Learned counsel.
Praying for minor repairing of my kitchen.
No, nothing.
I am running a
No, nothing.
minor.
No GA. Learned counsel for the petition. 6. 2 weeks time to file his reply to the affidavit in opposition. Interim order granted earlier, same. Extended for 2 months. List these matters on. When can we have it, Mr. Ghosh?
Immediate after the 3 weeks or 4 weeks, LOC takes it up. Because it will not take much time to dispose of the matter.
14th August, can 14th August.
And LOC said, well, the reply, he is filed reply, not opposition. Possibly,
Reply to the
in the last order.
Reply to the affidavit in opposition. Petitioner seeks and is granted 2 weeks.
Very good.
14th August briefly of এটা কার নিয়ে চলো না এটা আমাদের টেবিলে
Lordship, myself for the private respondent 7 to 11.
Your Lordship, this is my petition. Small application relating to a small parcel of land of 100 square feet. Unfortunately for my clients, it falls within a larger parcel of land. It is all part of a Thika property. Now, your Lordship knows for Thika property, if there has to be any kind of construction, that construction requires 2 types of permission. One is from the Thika controller under the Thika Act and the regulations therein, and also under the KMC. Now, what has happened here is there are multiple civil suits which were filed. The eviction suit has been dismissed for non-prosecution some time back. I am a Bharatiya, one of the small tenants. I occupy only 100 square feet at one Paka property, permanent property of 100 square feet. This falls within a larger property. Now, what has happened is I have got a civil suit injunction against forcible removal. They have got from the same court another action thing for construction. Now, I have no problem in the construction. They can do whatever they want. Now, what has, however, happened is when I presume when the construction permissions were taken from the NOC from the Thika controller and thereafter from the KMC, there has been no demarcation. And as a result, your Lordship will just have a look. I'll give them also a copy. This is what is happening. I cannot really access my property. The entire portion, that green part, small green room which you see, this is where I reside. Entire part has been dug up. And the plan is to construct over my property also. Keeping that aside, overarching, we see these things in China where they have one property is there, nobody has, everybody has constructed on top. This is the plan. So we have only given a representation, one in page 53 and one in page 54 and 73. One to the KMC and one to the Thika controller to have a look. Because there are guidelines on basis of which these permissions have to be accorded. We allege they have not been followed. And obviously anybody who looks at it, they couldn't have given permission, blanket permission, when my property with a civil court order, I'm just standing there. I just want my representation to be considered. At this moment, I don't want anything else. I just want my representation to be considered by the KMC and by the Thika controller.
Thika controller, you do whatever you want to do, not before me. All right.
Lordship.
As far as KMC is concerned, I can think about it.
Lordship, may I, if your Lordship permits me?
Yes.
Firstly, their own averments are self-contradictory and inconsistent with each other. Your Lordship will kindly come to page 11 of the application.
Application or writ petition?
Application, writ application.
Writ.
Paragraph 19 onwards. The private respondent number 7 to 11 applied for NOC before the controller, Kolkata Thika tenancy, but they have not filed the mandatory documents which is required for the NOC of the sanction plan of the building in the office of the respondent 2 and 3. And the respondent number 3 illegally and wrongfully granted NOC on 23rd 8 2024 in favor of the private respondents. The petitioner states that the municipal corporation issued the expenses of the sanction plan meant building number blah blah issued by the KMC of premises number this. Now, your Lordship, the specific allegation is that we have, by perpetration of fraud, submitted an affidavit before the KMC forging their signatures or whatever. Now, that was not essential at all. Kindly comes to page 45. This civil court order which they have relied upon in their own civil suit. Lordships, paragraph 2 onwards.
Yes.
Plaintiff is a tenant under the structure owner, that is the defendant number 1, in respect of one tile shed room measuring about 100 square feet at a monthly rental of 200 per month, payable according to English calendar month. On 2/11/2012, the structure owner, that is the defendant number 1, issued rent receipt from the month of November, December 2012 and January to July 2013. And thereafter, the said defendant number 1 took the rent for 4 months amounting to 800 as an advance in the second week of November 2012. But the defendant number 1 did not issue rent receipt. Defendant number 1 assured to the plaintiff to issue rent receipt. In the meantime, on 20/11/2012, defendant issued a notice to quit to the plaintiff to vacate and hand over the possession of the tenanted rooms. Lordship may kindly take note of this. Thereafter, defendant number 1 filed one title suit bearing number 16/2013 for eviction and recovery of khash possession before the second Munshif at Shialda. The date was fixed on 18/7/2023 for acceptance of the show cause by the plaintiff, and the plaintiff did not appear in the suit, and so the suit is dismissed for default on 18/7/2023. Next para. Plaintiff filed an application under Section 21 of the West Bengal Premises Tenancy Act 1997 before the learned rent controller at Shialda, bearing RC case number 303 of 21. At the best, his position is that of a trespasser. I do not consider him as a tenant at all. So, the petitioner.
So,
now your Lordship comes to page 50. The injunction by which I am protected. They have never challenged. They have never vacated the injunction.
They are not deciding title suit.
Are we deciding title suit?
Lordship, that is exactly what I am on. Let it be relegated to the
That's what he is asking. You only said you want to argue.
No, your Lordship, he wanted an inspection.
No, he never said that. What did he say, sir? What is your understanding of his submission? What did he ask for?
He perused for a representation.
Yes, representation, not inspection.
Lordship,
Representation.
by this court.
Representation by, he has made a representation to the KMC.
Lordship, in that case, let it be. But whether this writ court has, could be entertained.
Am I deciding title suit?
What I wanted to say, I am showing your Lordship, page 51 is the order of the court, where the court said that has got a sanction plan, he should not be restrained from carrying on the sanction building, construction of the building. That is his case. But actually, that was the order of the civil court, and we have taken instructions from the corporation and found that no construction is going on.
But your Lordship, I show the document, I show the pictures.
আমি তো নিয়ে এসেছি, এবার আপনি একটা থার্ড পার্টিকে দিয়ে ইন্সপেকশন করান।
Your Lordship, this is that's why I wanted a reconsideration by the KMC. If they are saying that there is no construction happening, but your Lordship, the pictures which I have shown with the dates and time,
there is no construction here, sir.
Your Lordship, it has been all dug up by it is for piling work.
It doesn't look like dug up, neither does it look like piling. Sorry, sir. I don't know how you look at the picture. Even we have some understanding. Where is the piling work going on, sir? How does the piling happen?
No, sir. First,
when you are putting a plinth on a property, how does it work?
Absolutely, sir. But the thing that they have not
You
placed
live in
that.
a house, you have constructed a building.
No, sir, your Lordship, this is
Where is the plinth?
Plinth has not been put in.
Where is the piling?
They are digging.
How do you
up
do piling?
Your Lordship, first they will have to dig up the entire part.
Where is the digging?
And there is the other.
Where is the digging?
Your Lordship, look
Yes, you can also throw anything on the land.
No, your Lordship, look at this part. This is the dug up.
Lordship,
and the entire
This is not dug up.
Lordship, in fact, they are demanding for a money which we are not ready to
Your
give
Lordship,
them.
this is
That is why they have
We are
filed.
not concerned with that. Asking for money, go file a case against him or her for extortion.
Lordship, there are police cases also.
Very good.
144 cases and all, but because
very good. Yes, Mr. Banerjee.
I can place that no construction is going on. But if your Lordship so ensure, my Lord can direct that we will see that no construction will go on. That also we can see. If your Lordship so directs.
No, you tell me you want to give a hearing?
Yes, if your Lordship so directs, we will give a hearing. But actually,
the only thing which he's asking for is
yes,
representation to be decided.
Both of them will be given.
The petition, the present writ petition is seeking.
Passing the order, may I take it?
Yes, is seeking the issuance of writ of mandamus directing respond number 2 to 6 to grant hearing on the representation of the petitioner dated 4/4/2025 and 16/4/2025 filed in respect of premises number 2A/H/14 Chhatu Babu Lane, PS Entally, Calcutta. Full stop. It is the case of the petitioner that he or she, he is the tenant of respond number. Your respond number
11.
11. Respond number 11.
7 to 11.
He is your tenant. 11.
Lordship, he is not my tenant.
That's
Yes,
it.
Lordship,
He's
from
an illegal
7
occupant.
He's the owner, 7 to 11, your Lordship.
He is a tenant of respond number 7 to 11. Coa 1 RT shed room measuring 100 square feet. Full stop. He alleges that the respondents are carrying out illegal and unauthorized construction over the said plot. Full stop. Learned counsel for the respondent states that there's a landlord-tenant dispute between the parties and the same is pending before the competent civil court. Full stop. The private respondents state that they have obtained a building plan dated 22/10/2024 qua the above mentioned premises for construction, full stop. The premises in question is situated on a Thika land, and in order to get the sanction plan, comma, it is mandatory for the structure owner for filing affidavit stating that no case is pending on the premises in which the sanction plan has been applied for. It is further stated that a NOC is required from the tenant. The petitioner states that without complying with the necessary mandatory approvals, the petitioner has obtained a building plan withholding necessary information and by misrepresentation. Full stop. He states that his representations dated so and so has 4/4/2025 and 16/4/2025 have not been acted upon. Full stop. Learned counsel for the respondent municipality, this Calcutta.
Yes.
Kolkata Municipal Corporation states that he is ready and willing to decide petitioner's representation dated 4/4/2025 and 16/4/2025. Full stop. Learned counsel for the petitioner states that his prayer is limited to the hearing of the representations. Full stop. He further states he shall be satisfied if the same is done within a time-bound manner. Full stop. In view of the submissions made by the counsel for the parties, this court directs respond number. Which one? Respond number 5. Respond number 5?
5, 6.
Respond number 5 can decide it. Respond number 5 to decide petitioner's representation dated 4/4/2025 and 16/4/2025 within a period of 8 weeks from the date of communication of this order, comma, after affording an opportunity is strictly in accordance with law, comma, strictly in accordance with law, comma, after affording an opportunity of personal hearing to the petitioner as well as the private respondents, comma, by way of a speaking order. Full stop. With the above direction, the presented petition is disposed of. None of the, since affidavits have not been exchanged,
Grateful Lordship.
none of the contentions are admitted.
Grateful Lordship.
Next.
The 19, I am appearing on behalf of the petitioners.
Yes.
Petitioner number 1 and 2, they are the senior citizens and they are the residents of a particular plot of area since 1989. The entrance and exit road of the entire area that has been narrowed down by the owners of private respondent number 6 to 9. Must complaints, must petitions were filed before the executive engineer, survey department, Kolkata Municipal Corporation, page 32, 42 and 40.
The copy, KMC, authority has not made a copy.
Copy the words. Yes, do you have served?
Let him give you a copy now, just now.
Just now, my lord, what happened in this case? Kindly comes to first, page 32. Page 32 first, I have annexed one sketch map. Kindly see the bottom portion. These two plots were extended on the road and thereafter the roads were narrowed down. No vehicle, my lord,
those ambulance, fire brigade are big cars. Those are not even, my lord, allowed, small cars. Kindly comes to page 37. These are the photographs. My lord, the 30 bolchi. My lord, kindly sees 37. This house, it has extended upon the road. How, my lord, I can show, if your lordship kindly comes to page 38. Page 38 kindly sees, they have cemented the, my lord, the road, and they have constructed a stair, a veranda on the road. My lord.
Where is your house?
Our house is my lord, into the area, but we have to go into the area. Thereafter, my lord, there is, our house is there. Total 32 plots are there into the Belgachi area. This is the entrance. These two are the entrance plots.
Your stays are not on the government land.
My lord?
Your house stays are not on the government land.
Well, purchased land, my lord. These are not government land.
No, no, no. You're saying encroachment.
Yes.
Encroachment is of what?
Yes.
Government land.
Our house, we have not encroached the road, my lord. We have not encroached the road. But there, these two houses, those have constructed upon the road and narrowed down.
Give a copy to him, we'll see it.
Extra copy,
Not today. We'll have it on 31st July.
31st July. 31st July. Great.
Give a copy.
July, 31st July.
Take instruction.
Sir, apna to phone number ta nahi hai. Grateful, my.
Yes.
But that is not the real fact, Malla.
We'll see that.
My application, Your Lordship would recall, is that LMNQ rooftop restaurant
LMN
in Park Street, where on 1st of May evening, there was a stop work notice. And on 2nd May, without there being a proper order, demolition work was undertaken. We had moved in on a vacation on 5th of May. They are assured that they will not take any coercive steps till the matter is heard. What has happened subsequently during the pendency of the writ petition, the CAC, we have also taken out an application for adding CAC a party because they have disconnected the entire electricity pursuant to the instructions of the respondents.
Yes.
This is a matter which is ready for him. Lordship, if they want to file an affidavit, is filed. Otherwise, I'll press my matter.
I am for CAC. First of all, we have not disconnected the entire building. This is the high tension line. Your Lordship knows, and the petitioner is not the registered consumer. The registered consumer has not been made party in this writ petition. We have got the intimation from the corporation. It is a rooftop building, and they have instructed us to take immediate steps for security measures for disconnection of the electricity. Since it's a high tension line, Your Lordship knows that there are several beneficiaries. We have intimated the registered consumer for taking necessary steps. The registered consumer has disconnected the portion of the premises, that is the rooftop. Only that part has been disconnected. Now, we are waiting for intimation from the corporation that what step we have to take. We have repeatedly given series of representation before the corporations. But till date, we haven't received any concrete instruction from the corporation side. This is our main submission.
I'll just indicate, Your Lordship. If Your Lordship would recall, the notice which is under challenge, it's at page 58. Number है भाई 53. पेज नंबर नहीं बताएगा तो मार देगा तो 53. Lordship, that's the notice which was given on 1st of May for stop work.
But they were
we were carrying on operating a business.
Yes.
So we were not carrying out any work. It was a 2021.
There was already an order passed.
Your Lordship,
other matters.
that matter is separate, Your Lordship, because I'll just indicate what has happened in here. The facts here, over there was no specific licenses to carry on the rooftop restaurant. In the given case, I was having the entire...
No, who says there were no specific licenses? They also had licenses.
Your Lordship, in the given case, notice of demolition was not given. The challenge here, your lordship observed that there was no notice of demolition. I received the notice on 1st of May and the demolition was carried on 2nd of May evening. When your lordship observed that there is no notice.
This is demolition 408.
Lordship, this is,
408, there's no notice.
your lordship, there is no order under 408.
This is the order.
This is a notice under 401. This is stop work.
Who appears for the corporation? You appear for the corporation.
And they have undertaken the exercise on 1st of May. They gave.
What is there, Mr. Bhattacharya, in this? You must have passed an order under 408.
Yeah,
What are your instructions?
আচ্ছা আচ্ছা এই তো first is kindly come straightway to page 25. 25 is the document which your lordship is seeing at page 53, subject to correction.
Yes.
Then, my lord, page 26 may kindly be looked into.
Yes.
This is the minutes of the meeting held on 2nd May regarding unauthorized construction at the roof 12th floor of 24 Park Street, Kolkata 7,16,000. Kindly read from in view.
Yes.
In view of the aforesaid, it has been unanimously decided that as there has been and continues to be a gross violation of the aforesaid rules and regulations, and the vital recommendations of the fire department are yet to be complied with, if the unauthorized construction is allowed to stand any further and the rooftop restaurant is allowed to continue operations, the same will very severely affect the people in the building who may need access to the roof without any hindrance in an unfortunate incident of fire or other calamity. This may lead to loss of human life and property. Considering the same, an emergent situation has arisen that the unauthorized construction at the roof level and all constructions to free ingress and egress to and refuge in the roof should be immediately demolished in addition to stopping the operations.
Page 27 is the order, sir.
Your lordship, the notice for stoppage of work was received on
Page 27.
I am at the order. The notice of stoppage of work received on 1st of May. The order has been passed on 2nd of May.
Now you have got this.
Ashok, I have got this now. The matter was there on 5th of May. When that time there was no order. Today the order has been passed after the notice of demolition was given to me.
Now you want to challenge this order?
Yes.
Challenge it. File a separate writ petition and challenge the order.
Very good.
Leaving counsel for the petition.
Lordship, in the meantime, the status quo to be contained. That was the assurance. I mean, they have.
What status?
They have assured that they will not demolish further.
Them. Learned counsel for the
Your Lordship, then in that event, kindly
discuss it. That's okay. Come.
No, till the time, kindly give me 7 days time. I will file a writ petition.
I will give you even a day, sir. They are saying that they are not taking any action. As far as this is concerned, it is a simple withdrawal.
It is understood.
It is a simple withdrawal. If you want, I will give my finding also. There's no problem. There's absolutely no problem.
Not any situation.
The court will pass an order, whichever way you want.
Only one thing. In that case, kindly.
Your betterment, so that you are not prejudiced by any of the observation, I'll simply allow you to withdraw it. If you want me to pass an order, I'll pass an order.
Kindly mix it up not to. I'll take instructions of the client. That's it.
There's nothing left.
I understand. I understand. I do not want to take it off.
Kindly not to demolish.
Learned counsel for the petitioner seeks time to take instruction. Likhwai do char. At least I'll record.
File documents.
Yes.
Learned counsel for the petitioner has preferred the present writ petition, seeking challenging the impugned notice dated 1st May 2025, issued under Section 401 of the KMC Act, 401 of the KMC Act, 1980. Full stop. Learned counsel for the respondent appears and states and hands over a report wherein the demolition order under Section 408 has already been passed for the property in question. Full stop. In view of the said development, learned counsel for the petitioner seeks time to take instruction from his client if he wishes to withdraw the present writ petition to enable himself to challenge the order under Section 408 of the Calcutta Municipal Corporation Act. Let this matter be listed on 31st.
CSC party, no.
CSC, they'll go to the other. I'm seeing him after long. I was holding that roster.
I'm appealing for the Kolkata Municipal Corporation. Perhaps the matter is under Right to Information Act, Lordship.
But page 14 may kindly be looked into. The application before the Kolkata Municipal Corporation. Then, my lord, page 16, this has been transferred under section 6.3.
So, sir, this is a RTI.
Only, my lord. The
RTI.
rejection may kindly be looked into, and the stand of this honorable court may kindly be looked into.
Why should
my lord,
I?
they have rejected.
Why should I?
That,
look into?
my lord, the first
Have your remedy available in law?
No, my lord, the first appellate has already directed them to supply all this information. Page 21.
You are aggrieved. Go to the.
No, I am not. I am aggrieved only not for supplying information, but at the same time, they are depending upon their law department, which, my lord, this honorable court specifically said no, they cannot do this under the act.
Sir,
That is why I am before
whatever it is, you have to file an appeal.
Only, my lord, a minute may kindly be spared, my lord. Why, my lord? Because
Mr. Chakra. Yeah, somebody like.
no, my lord, only, my lord, I think, my lord, as far as my realization goes, my lord, this is a, my lord, the fit case for intervention by this honorable court under group 5.
See, if you would have not moved,
Lordship.
and there was no alternate remedy available for you.
No, my lord, the alternate remedy,
Mr.
not the question. My lord,
If
whether
you have not got the document, you can go in appeal, say that the order has not been complied. You know there's a provision for penalizing them also.
Yes, my lord, the
The
rejection.
act itself is sufficient to take care of all your issues.
Only one document. Then I will conclude my argument. Only one document. My lord, page 24, then I will return, my lord. Page 24. To Manoj Kumar Sinha, with reference to your RTI application, Lordship got it, annexure P6. 1 minute, my lord. 1 minute, my lord. With reference to your RTI application, this is to inform you that as per the opinion of law department, the office of the state public information officer should be exercised independently without being influenced by any other authority. That is the mandate of the law. That is why I am before this honorable court. Whether this particular memo is to be sustained or to be rejected, then for any other purpose, I will go to the appropriate forum, my lord. And, my lord, I am supported by a judgment also. This honorable court deprecated this practice. Cannot be, my lord. SPIO cannot ask help from anyone. Relating to this High Court matter, my lord, CPIO of the High Court, and ask for, my lord, certain opinion from the register. Honorable Court was kind enough to deprecate it. This cannot be permitted in any manner whatsoever.
Take down.
If this Honorable Court kindly permit me, I can read, my lord, paragraph 18. My lord, 1 minute is over, my lord.
No, give me. I am never in a hurry.
18. Paragraph 18, my lord. Paragraph 18, my kindly be looked at. দুটো ছিল এই দুটো গেছে কি একসাথে দেখবেন সাহেবের কাছে দুটো গেছে হ্যাঁ 2017 3 ক্যালকাটা CMC 354
মানে কি হয়?
390 Last 4 line, my lord, paragraph 50. And my lord, 10 also, my lord, relevant. They cannot merely take the plea, it is within the exempted category of information. Each and every information will be, my lord, within the 4 corner of exempted category.
Yes, sir. আমার উপর দুজন সিনিয়র আছে
I'm supplying a copy to my learned friend also. No. আমার ভুল হচ্ছে না
Yes, madam.
I'm handing over the judgment.
I'm led by 2 seniors.
But I have not gone into this my judgment. Only my learned junior was, my lord, submitting to Lordship, my lord. Since this matter is under the RTI Act, possibly, my lord, if I am not wrong, my lord, it goes to the residuary bench. Because although the corporation is the party, corporation has been, the information has been asked to Kolkata Municipal Corporation, but all, my lord, the functions have been discharged under the RTI Act. Then there is a specific, in our court, my lord, the group and the matters have been provided, their classification, that goes because in many matters I have to do, my lord, before the residuary bench, the RTI Act. This is the one of the issue. If your lordship wants to hear the matter, then I will go through this judgment, my lord, and apply the
first,
lordship.
Mr. Chakravarti, find that out if the roster bench pata karo.
And residuary bench is there because I think, my lord, the KMC authority.
Then it should be, just because it is KMC doesn't mean that it should be listed
Right.
here.
There are land matters and all these.
Pertaining to RTI, and you are alleging that under the RTI Act, that order has been passed where there is some fault which is covered by this, then you
Their
go before
parent
the
act is Kolkata Municipal Corporation Act under Group 5.
Filed under
RTI. Check that up.
Yes.
Let this matter be listed, not today, 31st. Check that up.
31st.
Check that up. Check that up. You let me know on 31st.
Lordship, I will.
The group.
Residuary group 6
Group 9. Residuary group 9.
Residuary group 9.
Yeah, check that up.
Why do you know?
Residuary, he knows well, group 9.
Group 9.
Find that out.
Group 9.
ठीक है इसको नहीं इसको पता करो कहाँ लगना चाहिए ठीक है
After hearing, my lordship will, if lordship thinks fit, relegate this matter in the Group 9. Mr. Board.
Let me also see. I don't know whether it should be relegated to Group 9 or not. Let me find out from the registry.
Yes,
in corporation,
First is find out if,
in corporation matter, there is a provision for miscellaneous. Corporation, municipality.
That's a different issue. Miscellaneous does not mean the different act.
एक मिनट file दो. This pertains to RTI. एक मिनट file देना गोपाल.
This is clearly
Gopal.
miscellaneous are relating to the Kolkata Municipal Corporation, not specified in the group.
Take down. The presented petition, challenges the order dated 23/4/2025 passed by the issued by the State Public Information Officer, comma, whereby the information sought by the petitioner was denied on the ground that the same is exempted under section 8(1)(I) of the Right to Information Act 2005, comma, as it pertains to a record of deliberation of officers. Full stop.
8(1)I cabinet paper. 8(1)I, my lord, cabinet paper.
They have said it, the reason of denial is that one.
Yes.
Deliberation of officers. Record pertains to deliberation of officers. That's what it is.
Deliberation of the Council of Ministers, Secretaries and other officers. So it is a question.
Read the last line, sir, since the same includes record of deliberation of officers. That's what I've recorded. The case of the petitioner is that he had submitted an application dated 17/2/2025 under the Right to Information Act seeking certain information, full stop. Upon receiving no response, comma, the petitioner had filed his first appeal before the first appellate authority, full stop, by order dated 17/4/2025, comma, the first appellate authority directed the SPIO to furnish the requested information within 15 days, full stop. However, comma, by letter dated 23/4/2025, the said request was rejected, comma, reiterating that the information sought was exempted under section 8(1)I of the Right to Information Act, full stop. Agreed by the said denial, the petitioner, comma, the petitioner has referred the present writ petition, full stop. उससे पहले एक line लिख लो. The petitioner has
since they have short,
the petitioner states that the present writ petition, the petitioner states that the order, that the letter by which the information has been denied is illegal and perverse, since it records that the SPIO had taken the help, the opinion of the Law Department for the document as sought for, full stop. The mere reading of the letter dated 23/4/2025 does not, उससे पहले लिखो, has taken the help of the SPIO, which according to him is in contravention of the contravention of the law established in the case of Nasruddin versus High Court of Calcutta, 2017-3, Calcutta LT 394, full stop. Merely reading at the mere reading of the letter dated 23/4/2025 does not reflect the point raised by the counsel for the petitioner that the information has been sought with the help of the Law Department. It is merely stated that it is to inform that as per the opinion of the Law Department, which might be in terms of the information which is not to be provided and is exempted under section 8(1)I, the help of the Law Department could have been sought, full stop. In view of the same, this court does not find any illegality or perversity in the communication dated 23/4/2025 and is not inclined to entertain the present writ petition. The same is dismissed.
Deeply.
Number 22.
But I appear for the petitioner.
My lord, the petitioner purchased a flat space. My lord, after purchasing the flat space, the petitioner applies for mutation. My lord, the flat space was purchased in liquidation proceedings of a company, my lord. After purchasing, applies for mutation. Once the mutation has been applied for by the petitioner, the mutation application is not accepted by the respondent authorities, the KMC authorities, on a precursor, which they say that we have to obtain an NOC from the assessment office of the KMC as to the payment of the property tax in respect of the flat which I seek mutation of. But on that ground, my application is also not accepted. It's not a case where my application has been taken on record and then rejected. They don't take up my application, my lord. We make two representation even after
Application for mutation.
mutation under A42, my lord. My lord, the only, my lord, the distinguishing factor according to the petitioner, my lord, in this case is this was a purchase made in a liquidation proceedings governed by the Insolvency and Bankruptcy Code, my lord. And in the liquidation proceedings, the liquidator issued the sales certificate upon receipt of the entire consideration amount from the petitioner. My lord, your lordship is aware, my lord, of the clean slate theory in IBC sales and IBC sale proceedings, my lord. Even going further than that, my lord, when the sale was happening, my lord, when the company went into liquidation, the municipal corporation files an application. Kolkata Municipal Corporation files an application before the National Company Law Tribunal Mumbai bench, where the matter was taken up. My lord, they file an application because they say that my plea of property tax due on the property and the assets of the company, which is now going in liquidation, are due and payable, and I am a claimant of the corporate debtor company. My lord, that application is considered. The National Company Law Tribunal directs the liquidator to consider the claim of the resolution professional before the liquidator, my lord, to consider the claim outstanding of the Kolkata Municipal Corporation, and if it is found
in the list of
in the waterfall mechanism, my lord, under section 63.
Yes.
My lord, all of that happens. Thereafter, they are not satisfied with the claim which was adjudicated and considered and accepted by the resolution professional. They file another application. The second application also meets with the same fate, my lord. Now, today, my lord, my application for mutation is not being taken on record by them,
there must
citing
be
the
a
same.
there must be an outstanding amount.
Yes, my lord, there is an outstanding amount according to them. My lord, but my lord, if your lordship, my lord,
Can they accept?
my lord, that outstanding amount, my lord, with deepest of respect, two provisions, my lord. One is when the company is being sold by an NCLT proceedings by a liquidator, my lord, appointed in the NCLT proceedings, my lord. It is the company's assets individually which are being sold. My lord, now in that, my lord, Ghanshyam Mishra and the follow-up, my lord, I saw your lordship had considered one matter, my lord, so I will, yes, my lord, I was here
Covered
in,
by that judgment of the Supreme.
yes, my lord, Ghanshyam Mishra, and thereafter, my lord, even in tax-related matters, in other property tax-related matters, my lord, the crown debt has been established by the Supreme Court as to what falls within the mechanism of crown debt and what does not. And my lord, in all the judgments, my lord, with deepest of respect, my lord, it has been stated that in liquidation proceedings, a person who is buying a property for valuable consideration, he gets a clean property, my lord, and any liability has to be paid by or discharged by the liquidator in the waterfall mechanism.
Mr. Mukherjee, I have passed a judgment.
This aspect in the other matter also, trade international, it is different from this. What happened in trade that went into liquidation, then consortium was elected.
Resolution plan.
In terms of that resolution plan. And the owner of the property remains owner. It's not, the property doesn't go into liquidation.
Yes, it does.
He still continues and manages
That
the
is how-
property, but under the guidance of this
I
consortium.
IRP.
Now, here, the other cases, I was trying to persuade your lordship. Those cases are different. Here, once the resolution thing fails, then the assets and the property has to go into liquidation. Now, the liquidator is appointed. He invites, first he gives the notice. Sell notice.
Yes.
Then he publishes those expression of interest, which they download. Based on that, they apply. Now the bid is accepted or it won't be accepted. But in this case, his bid has been accepted. Now the conveyance goes. Sale, naturally, sale is complete. Now I do not question the fact that I am an unsecured creditor. The law says so. If I am an unsecured creditor, I am an unsecured creditor. But at the same time, my lord, there are two provisions in the Corporation Act. One is Section 183. The other is Section 232. 183(5) reserves a right by which corporation reserves the right not to grant mutation unless my past dues are paid. And 232 says, whatever the dues are, that runs with the property.
As a first charge.
So it becomes a first charge against the property. So 183(5) read with 232, but no one can shy away. Now that money has to be paid if he intends to get his new mutated, because these two provisions still stands in the book, not deleted, not being commented upon by any court. And my lord, there are two judgments which I would be placing when your lordship hears this. One is a coordinate bench judgment, and the other is
The one you have shown me.
No, that is not
the one.
That, my lord, that was on a aspect I will be taking up just now. Now that is on mutation. 183(5) read with 232. There are two judgments. One is of the coordinate bench. Honorable Justice Girish Chakraborty as his lordship. Then there is a division bench judgment. That other one is Rosomai Das. The second one is Ram Niranjan Agarwal. Kajari. Mother, that is the division bench judgment, which in the last paragraph, paragraph 17, makes it abundantly clear that the corporation is not bound to give mutation unless the past dues are paid. That is one aspect of the matter, so far as my learned friend is saying about the mutation. Now, my lord, would kindly take page 75. Learned friend is a very forceful speaker. I respect his exuberance.
Directly
No, my lord. I do not know whether your lordship's page 75 is legible.
Difficult, but yes.
It is legible. No, my lord, by straining my eyes, I am reading it.
Yes.
My lord, the first paragraph, the fourth, 1, 2, 3, 4, fifth line. Fifth line, if your lordship sees,
Not legible at all.
Lord, as is where is, whatever there is basis. Lord, I'll not shy away from this.
and no recourse.
Yes, my lord. This is admitted position. My lord, I apologize for the copy on the petition.
This is the aspect.
This will add to my power.
My lord, I apologize for this. We'll file a fresh copy of this page.
Circumstances under which the same took place. Now, my lord, would kindly drop down.
Yes.
Drop down to 1 and 2.
This trial.
Yes. Hey,
Lord, this I also can't read. I apologize. I'll file a fresh copy of this page, my lord. I absolutely. Even technology is not perhaps assisting us in this.
Sale will be done. Sale will be done by the undersigned through e-auction under
E-procurement.
E-procurement. E-procurement.
E-auction service provider. No, it is stated sale will be done by the undersigned through e-auction service provider, e-procurement, auction. The sale should be subject to the terms and conditions prescribed.
1 and 2 is very
Terms and conditions prescribed in the
Process memorandum.
Process memorandum
available on website.
Yes.
Now,
that has not been annexed.
it has not been annexed, but it is declared that the liquidator does not take any responsibility. Whatever 1 and 2, whatever facts are given are, my lord, there might be some mistake in those facts and figures.
আমি পড়ে দিচ্ছি।
Lord,
The
may I just, I'm
particulars-
not
the part-
interjecting my learned
The
senior friend.
particulars of the assets, the particulars of the assets specified in the
The set of assets have been stated as per
based
information
based
on
information available to the liquidator on
bona
bona
fide.
fide basis. It is bona fide basis. It is
Lord,
contained
may
by the liquidator.
Lord, may I make it shorter, my lord? This document, perhaps it's a document annexed by me. Process memorandum is also something that I cannot run away from, and I do not wish to run away from it, my lord. But there are 2 points, my lord, which is before your lordship. Rightly stated, because I am not carrying the Shay judgment of your lordship, also because, my lord, there are 2 purposes of IBC, my lord. One part is the resolution sale.
No, but this might be different than the.
This is, yes, absolutely. That is why I'm not relying on Shay for that purpose, my lord. There is one part of IBC, which is a section 14 resolution professional moratoriums. Company is sold as a going concern. My lord, when that fails, then it falls to the liquidation mechanism. Age-old principle, my lord. Earlier Companies Act, now IBC has taken over. My lord, when it is a liquidation sale, then the situation is that the assets, each and every assets are sold separately of the corporate debtor. Whatever the amount is recovered by the liquidator, that is then distributed in the waterfall mechanism to the creditors of the company. My lord, in a liquidation sale, when an individual asset is also being sold, my lord, in that situation also the claimant which is existing of the company, my lord, my learned senior friend pointed out that there is a claim. The claim may be with regards to the property as per the KMC Act, my lord, but the claim was against the erstwhile owner of the property, which fell in the ambit of the corporate insolvency resolution process. My lord, it would have been a different situation if the authority would not have gone before the company which was the company court which was handling over the liquidation proceeding sale.
Assuming your argument is correct.
Yes, my lord. Now coming to
Let us assume your
yes,
argument
yes,
is
my lord.
correct,
Now
that they are
in the
in the
mechanism.
list. All right. They have not recovered,
No.
but you should be given the mutation because you have purchased the property.
Yes.
So they should forego
No,
their
my lord,
property
my lord,
tax.
it's not a case of foregoing, my lord. That is where, my lord, I seek to just, my lord, indicate to your lordship, my lord, foregoing would have happened where somebody's right is not being paid. My lord, this is not such a situation because, my lord, here the asset which was held by the liquidator for the company till the time it was sold to me, my lord, it had certain assets, certain liabilities attached to that property, one of them being the property tax due. My lord, under the IBC mechanism and section 53 thereof, my lord, in the chart of who are the debtors of a company, falls the debts of not only the property tax of a corporation,
Any tax.
any tax, income tax,
Any statutory
GST,
duties.
statutory duties. My lord, now with the development of the judgments on IBC code, my lord, which I want to point it out to your lordship before your lordship comes to a finding on this matter, my lord, I'll take that chance before your lordship. My lord, they have rectified it to an extent that in liquidation, when a property is being sold, individual property is being sold, my lord, if the claimant has come before and his form has been accepted before the liquidator, my lord, then there is where he gets his money from. My lord, I'll try to establish before your lordship. My lord, I'll show a few judgments, my lord. It is not with regards to
The
KMC
last
property tax.
judgment is the one where I've relied on Shay.
My lord, there is
That's the 2024 judgment.
there's a 2025 Vaibhav Goyal also, my lord, 2025 Supreme Court. My lord, there are several issues which are developing on the IBC code, my lord, with regards to what would happen when and what would be the clean slate and what would not be. A clean slate with regards to resolution professional sale or the sale during that period is now well established. My lord, what is the Shay judgment which your lordship has also considered? My lord, the second aspect is when it is sold in liquidation. My lord, that if your lordship finally, my lord, after taking up all the judgments and my lord, my submissions, my lord, whenever your lordship takes it, my lord. This is the limited point.
Take down. The petition in the present writ petition is agreed by the inaction of the respondent, whereby they have refused to accept the mutation application form filed on behalf of the petitioner to carry out the mutation of the commercial premises being unit number A. What is the unit number?
My lord, the unit number is 13 by 1 by
No,
1
unit number 1 at the first floor. Where is that?
Tura East Road. 13 by 1 by 1A.
Being unit number 1, first floor, comma 13 by 1 by 1A, Shura East Road, PS Beliaghata, comma CIT Road, Calcutta. In the name of the petitioner, on the ground that there is an outstanding property tax qua the said premises. Full stop. It is the case of the petitioner that the premises in question was originally belongs to the MS Talwarkars Better Value Fitness Limited. Full stop. The said company went into liquidation and finally official liquidator was appointed. Full stop. The petitioner purchased the said property through e-auction for a total sale consideration of 4 crores.
Yes, my lord. 4 crores 75 lakhs.
4 crores 75 lakhs. Full stop. The said the sale certificate. When was the sale certificate issued?
My lord, the sale certificate was issued, my lord, on 16th January 2020.
The sale certificate was issued in favor of the petitioner on 16th of January 2025 in respect of the said premises. Full stop. The petitioner approached the respondent municipality for carrying out the mutation of the said property in their name. Full stop. However, the respondent municipality refused to accept the said application on the ground that no mutation can be carried out till the clearance of the property outstanding property tax. Full stop. Learned counsel for the respondent municipality. In view of the said refusal, the petitioner has approached this court by way of the presented petition. There is anything else to be recorded?
No, my lord, that's it.
Or the stories of Mumbai and all?
My lord, that may be on final hearing, my lord, may not be recorded, not recorded.
Learned counsel for the respondent corporation seeks and is granted 4 weeks time to file affidavit in opposition. File your affidavit in opposition.
So file a supplementary affidavit.
I'll just indicate.
Those documents and the expression, terms and condition and expression of interest, the booklet.
Learned counsel for the respondent seeks and is granted 4 weeks time to file his affidavit in opposition. Learned counsel for the respondent also points out that the petitioner shall file his expression of interest and other terms and conditions of the e-auction through which he has purchased the said premises. Full stop. Learned counsel for the petitioner states that he shall file the same by way of a supplementary affidavit within a period of 2 weeks.
But may I file it in?
हाँ वो लिखा ना affidavit in opposition, reply to the same if any within 2 weeks. उसके बाद कर देना ये.
May I file it in with my reply if that, because otherwise 4 weeks time direction.
For my affidavit in opposition.
I'll file a supplement.
4 weeks time after he gives me.
That is exactly what.
ये जहाँ वो लिखा 2 weeks लिखा ना? No, उससे पहले ये sentence पहले डालो. जहाँ लिखा ना petitioner के submission के बाद, it is pointed out by the learned counsel for the respondent. Yes. By way of a supplementary affidavit within a period of 2 weeks. उसके बाद करना, learned counsel for the respondent shall file his affidavit in opposition after the petitioner has supplied him with the supplementary affidavit within a period of 4 weeks. Within a period of 4 weeks thereafter, a reply to the same, if any, within 2 weeks. List on this will go in
8 weeks.
August 28th. 28th. 20th is too auspicious for me.
Milord, just one correction, Milord. Official liquidator, it won't be official liquidator. It's just liquidator now under the
liquidator.
Deeply.
Grateful.
Number 23.
Lord, I appear for the petition of Lord.
Yes, sir.
My Lord, may I file the affidavit of service?
Who are you are appearing for KMC?
My Lord, the private respondents were received it 1 day late, my Lord. The service returns are there, my Lord.
Who are the private respondents? Very difficult
My Lord,
to.
this respondent number 5, my Lord.
Submission, my lord, before my letter starts. If my lord.
Affidavit of service taken on record. Yes.
My lord, refusing petition. It appears, my lord, in respect of they would to restrict. And my lord, only
In respect of, please speak in the.
they would to restrict, my lord.
This one also.
Is this one also? And my
You
lord,
are an expert on the Debattur state.
no, I am not expert. I am trying to learn the law, my lord.
Every matter he comes with
I am
Debattur.
trying to learn the law. And my lord knows that my lord will find from the cause title that Bhukoilas Devottur estate. The respondents have been added in this manner. And as my lord knows, the deity is a perpetual minor. The law of the land is, my lord, the deities are to be made party through their sebites.
Yes.
All the sebites are there.
Yes.
Well, none of them have been made a party. But
My
this
lord,
is
that
definitely, and thereafter, my lord, on merit, my lord, because I don't have any instruction as yet as it appears.
No, if it's a Debattur property, you have to make the deity a party through
My
the
lord,
Shebites.
The Devottor property, the estate, was represented by their Shebite at the hearing, my lord. And your lordship will note, once I place these orders, my lord, your lordship will note that they had.
So who's the Shebite here?
My lord, one Mr. Ghoshal, he's the managing Shebite, my lord, and who had appeared, who had filed documents, even in the earlier.
But where have you made him a party?
My lord, he individually is not made a party.
So you have to make the Shebites a party, sir.
No, my lord. Subject to your lordship's correction, my lord. I do not know how many Shebites are there. Bhukoilas Devotto Trust is a very old trust, very, very old trust, my lord. There may be hundreds Shebites spread all over the
So
globe.
generally, Shebites are not 100. Shebites are limited.
No, my lord.
Limited.
I beg to.
For the trust, there must be.
No, my lord. The Shebites, my lord. Like in my family trust, my lord, I am a Shebite. My cousin, who's also a Shebite, lives in California. So therefore, my lord,
Parties have to be made.
My lord, not all those Shebites are, my lord, are to be made party because I have made the trust a party. The trust is represented by the managing Shebite, who Mr. Ghoshal, who had appeared before the authorities.
But here also, Mr. Ghoshal is not a party.
My lord,
where is Mr. Ghoshal a party?
My lord, he was representing the trust, my lord.
Sir, but you will make somebody. You are just make Bhukash Devattar state.
Very well, my lord. If your lordship so pleases, my lord, I'll make Mr. Ghoshal a party and I'll come. My lord, I'll come back before your lordship.
Well, deities are also required to be made.
No, deities are not required, my lord.
Yes, my lord. That is perpetual minor, my lord. He has to be made a party.
Deities
the
have
estate
to be,
belongs to the deity.
Yes, the state belongs to make deity a party. Make Mr.
There are numerous deities, my lord. In my family trust, my lord, there are numerous deities, my lord. When litigations are filed,
Then we will first decide on the preliminary issue of maintainability as far as the array of parties is concerned.
very well, my lord. To obviate that difficulty, my lord, I'll make the deities as well as the managing Shivaites who had appeared at the hearing, even before your lordship's court in the earlier occasion, my lord. I'll make all three of them up parties, my lord, and come back before your lordship.
That might help. Learned counsel for the petitioner seeks liberty to add necessary parties to the necessary respondent, a party to the present proceeding, i.e. should I record or I'm just passing you
necessary,
necessary.
Because this, had they appeared today, my lord, the entire problem would have been
May I get a amended cause title at least, my lord? Not
Yes, once they will make it, they will give it to you.
Nice.
Returnable date. To amend the cause title and to add other respondents to the array of parties. Full stop. Let the same be done within a period of how much time? Within a period of 2 weeks.
Obligement. My lord, and the matter to come up before your lordship.
Let this come on the
7th of August, my lord.
14th. 14th August.
Hmm?
14th.
My lord, may it be on 21st, subject to your lordship's wisdom. My learned friend.
21st will be then 28th.
Very well, my lord.
28th August.
My lord. My lord.
Inform Mr. He just left. Mr. Banerjee.
Mr. Banerjee.
Inform Mr.
My lord, in
Banerjee.
that case, my lord, may I get one more week, my lord?
Then 20th, it will go to 4th of September.
No, my lord.
For the amendment.
For the amendment, my lord, one more week. Well, your lordship had given me 2 weeks. That's
Yes.
up to
So 3
31st.
weeks. Okay, I'll grant you 3 weeks.
Yes.
Next 3 weeks.
3 weeks.
But the date would be for 28th.
Yes, yes.
Just inform Mr. Banerjee.
Yes, sir, I'll inform Mr. I'm grateful.
28th August.
I beg to appear, my lord, for respondent number 8 in this matter.
I am for the petition, my lord. Let me place my case first.
But am I audible to your lordship, my lord?
On behalf of the private respondent number.
Private respondent speaks last. Yes.
Lord, am I audible to your lordship, my lord?
Yes.
Lord, am I audible to your lordship, my lord?
Yes, Mr. Karmakar, you are audible.
Yes, good. Very.
Not here.
From your beautiful office.
Lord,
My lord, this is an application in respect of a building at 65 Bentnick Street. This, my lord, has been declared to be a dangerous structure under the provisions of section 411 subsection 2 of the KMC Act. So, my lord, this is condemned and this has to be demolished. Now, my lord, I have made an application for grant of fresh sanction plan. Your lordship will kindly take the index right at the top, my lord. Page 13, your lordship will find the declaration.
Page?
Yes, my lord. Page 13 is this declaration that this is a dangerous structure, my lord.
Page 14 then. Page 14.
If your lordship will kindly turn to the next page, my lord. Yes, at the bottom, lordship will find 2024, my lord, declaration is made that this is a dangerous structure. At the next page, your lordship will see the condition of the building. And kindly see the notice board affixed, my lord. Bipod Janok Bari, which
This
means
is
dangerous.
dated 2000.
I beg your pardon, my lord.
What is the date of this notice?
My lord, kindly see page 14 at the bottom.
2018.
Yes, my lord. 2024.
And also the
This is for 24-25, my lord. Now, my lord, the issue is that I have applied for a new sanction plan. If your lordship will kindly see the application term. Sanction plan application page 36, my lord, I have made an application for new sanction plan. From page 35, your lordship will find This is my application for new sanction plan. And my lord, I have given a declaration at page 38 that there are certain tenants in this property, my lord. There is one super tenant and 6 subtenants under him. My lord, I have undertaken to rehabilitate all of them in the structure to be constructed as per the sanction plan. The supertenant under whom other occupants are there, he has accepted and he has filed, my lord, no difficulty, and that I have undertaken to rehabilitate him. And page 38, my lord, will find I have made a registered declaration that, my lord, I will rehabilitate all the occupants in the new structure. Now, my lord, what happens? Kindly see page from page from page 38. This is the declaration, my lord, that accompanies my sanction plan application. If your lordship will kindly have a page 41, clause 8.
Just a
May I place
minute,
it, my lord?
just a minute. You're in a hurry.
No, man.
Then
Lordship will kindly see the declaration from page 38 at 41. May I place it, my lord?
yes.
Further, I declare that I shall not evict any tenants or occupiers from the said land. In case it is necessary to remove any tenants or occupiers from the said land, I undertake to provide, relocate.
Where are you reading?
Page 41, my lord, clause 8 at that page. That is part of the declaration that starts at page 38. May I place it, my lord, at page 41? I say that further I declare that I shall not evict any tenants or occupiers from the said land. In case it is necessary to remove any tenants or occupiers from the said land, I undertake to provide or relocate the said tenants or occupiers with identical area in or around the said land premises by mutual agreement under the provisions laid down under the West Bengal Premises Tenancy Act 1997. And my lord, if your lordship will kindly have the, my lord, Kolkata Municipal Corporation Building Rules of 2009. May I hand up a copy, my lord? The relevant rule is Rule 42.
Rule.
42 টা আছে তোমার কাছে রুলটা? And I beg your pardon, it's Rule 142. Sorry, so thank you. Yes.
Just give me.
82 hand. আমার কাছে সব কপি আছে।
एक मंगा लो ना ये बिल्डिंग रूल्स। Yes. Yes.
Yes, my lord. If your lordship will kindly allow me to place Rule 142. My lord, 142 is old and insecure building. Application for permission to reconstruct buildings in the place of buildings which are more than 50 years old or have been damaged by natural forces and which are partly or fully occupied by tenants will be considered on the basis of relaxed requirements as contained hereinafter in respect of their reconstruction on the basis of recommendations of the Municipal Building Committee as may be accepted by the Mayor and Council, provided that the applicant provides to the corporation proof of settlement with all the tenants either in the matter of their rehabilitation, if your lordship will see thereafter, A, FAR to the tune of such and such 50% of the area presently occupied by the tenants will be allowed over and above the FAR being presently enjoyed. Height, car parking, etc. These are provided. So this is the rule I have to comply with. My lord, I have given a registered undertaking that I will, my lord, put them back in possession of equivalent or more area in the building to be constructed pursuant to the plan for which I have applied. I have obtained, my lord, the consent of the super lessee under whom they are occupying. If your lordship will kindly see that now, my lord. Super lessee data NOC will at page 50, my lord, if your lordship will kindly have. Page 50. This, my lord, Mr. Syed Ijaz Hussain has, he is the supertenant. Kindly see at 51. May I place it, my lord?
Yes.
Page 51, that I am the supertenant of the above referred premises since 40 years. I am presently occupying the whole building, including 88.187 square meter shop, 58.023 square meter go down, and 290.811 square meter residential at the said premises. I shall have no objection if the present owners or their representatives construct a new building thereon after demolishing the existing old and dilapidated building and agree to rehabilitate in the new constructed building with an area of 88.187 square meter shop, 58.023 square meter go down, and 290.811 square meter residential. I am enclosing here with attested copy of Aadhaar card, etc. If your lordship will kindly see the plan application number from page 30. Yes. From page 35 onwards, my lords. This is the application I have made. And the plan for which I am seeking sanction, my lord, is from page 36. Lordship will have a fold out, my lord. To indicate.
Statement of
My lord will kindly see at the, if your lordship has the fold out, my lord, area statement in the middle fold, my lord, right under that, area statement of tenants. Lordship will find existing and proposed. So, my lord, name of the tenants to be rehabilitated, they're all mentioned by name. Existing area that they are occupying and enjoying is mentioned. And, my lord, the proposed area that I intend to allot to them, that is also mentioned. So, my lord, humble submission is there can be no, my lord, embargo or impediment to granting the sanction, my lord. I have also obtained the clearance from the fire authority, my lord, which your lordship will find at page 61. That is issued on the 21st of February, 2024. If your lordship sees the subject, that should suffice, my lord. Fire safety recommendation for proposed construction of G+6 story, partly residential, partly commercial building under principal group of residential building at premises number 65 Bentinck Street, ward number 46, borough number 6, Kolkata 700009, under KMC such and such. The lordship will see the first paragraph. This is in reference to your. Lordship will kindly take the second paragraph thereafter. In the middle of the page, the plan submitted by you was scrutinized and marked as found necessary from fire safety point of view. In returning one set of plan with recommendation, this is issuing fire safety recommendation in favor of the aforesaid building, subject to compliance of the following fire safety measures. So, my lord, I have complied with all the extant regulations. Yet, my lord, because these sub-occupants under the super lessee are resisting, my lord, they are naturally negotiating for a higher, my lord, consideration or larger area to be allotted to them in the constructed premises, my lord, they are holding out and not according their consent freely. So that is holding up, my lord, the approval of my application, even though I am, my lord, in compliance with the extant regulations.
Yes.
So, my lord, this annexure, I cannot read anything. We have filed an annexure giving a very copy which is.
Give a better copy.
That I can hand up, my lord. No difficulty.
Secondly, my lord, they have suppressed that suits are pending before the citizen. In one suit, there is an injunction. Kindly, this is my report. This is my report.
What are the suits?
My lord, interim order, if any, has been vacated, my lord, I am instructed. Key baat hai, follow. Let's go. তাই তো জানি না।
যে কাগজ দেখাচ্ছে আমরাই
Yes.
The lordship is the circular, relevant circular, and that is the letter submitted by the tenants who have not given consent.
What is the status of your suit?
My lord, if your lordship permits.
May I, my lord,
Your Lordship, on that.
But what has happened, my lord, the corporation has indicated to us whether any suit was pending regarding the after filing of the writ and the sanction plan. But we had indicated, we ourselves has sent them a letter indicating that these suits were pending and then interim order was there. And now currently the interim order has been vacated. This is the order that has been passed by the learned court below. Interim order has been vacated.
Give it to the corporation.
This was
Swami.
passed on 25th June
Okay.
2025.
Inform the corporation.
It was informed to the corporation also.
Which letter kindly give me a copy?
But however, this does not affect the property. My lord, my scope of the writ petition is regarding the sanction plan approval. But I have complied with all the directions that are there in the circular that has been given by by my learned friend.
Regarding the filing of no objections by the tenants. We are guided by that, the Municipal Commissioner Sergeant.
Now, my lord, with respect to, my lord, once if your lordship permits me to make submission, my lord.
But I have not completed if.
Achha, very good. After you complete,
Division order, there are division bench order where, my lord, the division bench has come across the similar circumstances. My lord, this was the order that was passed. Kindly take page 3 of the order. In this case, what has happened? The tenant had filed the appeal before the division bench as because the plan was given and the name was not given in the proposed sanction plan. But my case is better than that. I have given their name in the proposed sanction plan and there is already a notice issued by the KMC regarding the dangerous building demolition. And now I am currently reading from page 3, first paragraph. Being the writ petitioners carried such order of this learned judge, this bench, by a judgment and order dated, noted that the prayer of the writ petitioners before the learned single judge was for cancellation of the sanction plan. The appropriate authority to consider such prayer under section 397 of the KMC Act is the municipal commissioner. This bench opined that the learned judge should not have entertained the writ petition at all and should have directed the writ petitioners to take recourse to the procedure provided in section 397 of the KMC Act. Thus, my lord, the tenants have a alternative remedy. They can go under section 397. And my lord,
that is a subsequent thing, sir.
Furthermore, my lord, thereafter
that is after the sanction of the building plan. They can go for cancellation.
Yes, my lord. That is the thing. My lord, kindly come at page 4.
Sanctioning at this stage.
Yes, but I am only providing what has been declared by the division bench. My lord, I am coming to that. My page 4. Page 4, there was an order for demolition passed by the KMC under section 412A. And my lord, page 6. I am reading the second para. Mr. Sengupta, learned advocate representing the writ petitioners, vociferously argued that without first providing for space in the building plan sanctioned by the corporation, wherein the appellants could be rehabilitated in the reconstructed building, the appellants cannot be required to vacate the premises in question, nor whatever remains of the building can be demolished, as the appellants are still in occupation of the portion of the building which has always been under the tenancy. He says that as soon as the right of the appellants to be rehabilitated in the reconstructed building is reflected in the sanctioned building plan, the appellants will vacate the premises. This was the stand of the tenants. Now the division bench. We have also heard the learned advocate for the owners and developers. He says that the court has protected the interest of the appellants sufficiently. The appellants have approached a competent civil court. That itself shows that there is a dispute as regards the tenancy right. If they succeed in the civil suit that they have instituted, their names will be incorporated in the sanctioned building plan and they will be duly rehabilitated in the reconstructed building. However, as of now, the appellants cannot insist on incorporation of the names in the sanctioned building plan who are tenants as precondition for vacating the premises to enable the authorities.
It goes against you, it doesn't favor you.
But I have already incorporated their name in the sanction plan. That is my stand. And my lord, thereafter in the page 7, in the first para, I am reading from the 4th line. From the papers on the record, as also from the submissions of the parties, it appears that the building is in a dangerous state, posing real threat to life and limbs of the people in the vicinity thereof. Similar as the petitioner's case herein. A substantial portion of the building appears to have been demolished already. It is imperative that the appellants do vacate the premises at the earliest to enable demolition thereof. We reiterate that in the event the appellants succeed in the civil suit, the names of the appellants, this is not irrelevant. But
my only prayer before your lordship, my lord, the building is in dangerous situation and there is a notice already issued and the board is already annexed at the front of the building. Our application may be processed in the meantime, my lord. Whatever stage the tenants will take after sanction, after approving of the sanction, not before that. And I have already given them the adequate portion that they are holding right now in the proposed plan.
At this present stage, this judgment is not applicable because Mamalat, there is this particular litigation which my learned friend prefers the place this judgment. There are 3 writ petitions.
Yes.
Ultimate writ petition matter was delegated to the authority for passing an order under section 412A. That stage has not come as yet in this present case.
Okay. Yes, what do you have to say?
May I, Lord?
Lord.
Lord, I appear for respondent number 8. Lord, one of the private respondent claimed to be the
Thereafter, respondent number 9. Let him first argue thereafter.
You are for respondent number?
9.
I am for the
Nine.
respondents 5 and 7.
I am
Tenants.
respondent number 6.
Tenant.
Very good.
We are all private tenants.
All
Lord-
private tenants.
Yes, lordship comes to the cost item, please.
Yes.
The name of the writ petitioner is T.O. Solvex and Industries Limited.
Yes.
Your lordship comes to page 5. Paragraph 6. Presently in the said premises, there is one supertenant, namely Syed Ijaz Hussain, and under him there are 6 tenants, namely such and such. I am for Shiva Swing Machine and Rohit Shaw and Rahul Shaw.
Yes.
Your lordship kindly looks at the rent bill. The rent bill is issued by the petitioner, lordship. It's issued by the petitioner. And in fact, I am enjoying 2 tenancies. The top one and the second one. The second tenancy is not mentioned. The second tenancy, Gopi Chand Kaushik, is not mentioned. And Gopi Chand Kaushik has died in 1995 when the new tenancy act not come into force. Therefore, we are guided by the 1956 Act, lordship. Lordship, this can only be disposed of on an affidavit. Let all the facts come on record.
Lord.
Yes, Mr. Karmakar.
Yes, Lord. Lord, kindly takes up, Lord, an argument was made, and Lord, in paragraph 6 also, Lord, they have stated that, Lord, the supertenant is there, Syed Ijaz Hussain. Although, Lord, he is not a party to this proceeding, we do not know about this, Lord, signature. Let us take it for granted, Lord, that he has given this signature. Lord, kindly comes to page number, paragraph number 9 of this petition.
Yes.
Such and such already issued out of the aforesaid tenants. This then, my lord, kindly comes to paragraph number 11. But unfortunately, the private respondents number 5 to 9, being the tenants of the said premises, have deliberately refused to such and such. My lord, kindly thereafter comes to paragraph number 12. None of the aforesaid objectors being such and such are actual tenants of the petitioners. They disturb. My lord, this is the situation. In this situation, my lord, this T.O. Solvex goes and files a suit for eviction under the Premises Tenancy Act against me before the Small Causes Court. So, my lord, either that, my lord, suit which is pending, that is ejectment suit number 134 of 2025, either that is, my lord, a complete, my lord, incorrect statement, or this is an incorrect statement.
But may I show the order that has been withdrawn? Yes. Suit has been withdrawn.
Now, my lord, if suit has not kindly seized the modus operandi once, my lord, I carry out a commercial, my lord, it's a shop room out there. My lord, I carry out, my lord, commercial transaction from there. All the tenants are, my lord, tenancies are for commercial purpose only. Now, my lord, here they are trying to get, my lord, me evicted by filing an eviction suit, and at the same time, my lord, setting the ball in motion from the corporation so that they get the building demolished and I get out of the possession. This, my lord, the situation continues for next 3-4 years without me in possession, or I am not being granted any other alternative space from where I can carry out my business. They are only showing that, my lord, they are giving me the space under 142. Lord, what about the time that, Lord, I will spend out of this premises? Because I am as on date paying rent. Whatever under the obligation, I am under the Premises Tenancy Act.
You know, Mr. Karmakar, they'll rehabilitate you. They have to do that.
Lord, they are not saying in the petition, there is no single sentence, your Lordship would find, that says that they will be rehabilitating me during the time of construction and thereafter they will instate me.
Paradise developers.
And now, Lord,
You have said so.
Lord,
There's no such provisions to rehabilitate immediately.
Yes.
After I get approval, then only I can rehabilitate him.
Lord, first let us agree on that.
Great.
How will I rehabilitate before?
Give
No, I
the
am out of my
proposal.
The proposed, I have.
Where is the proposal?
For rehabilitation, my lord.
Yes.
I do kindly see and give it.
Lord, the submission which have been made by the other private respondent, I am totally on seconding to those submissions, and adding to the submissions, my lord, I am submitting one more document that the owner has assigned his entire right of that property to a third party. Now
that's okay, that's a builder.
And
He
thereafter,
can always do that. That is their development agreement.
he's
He
not
can
a builder.
enter.
He's the
No, Lord, what has happened here
the
is,
owner of
Lord,
the
development agreement was there. Lord, 60.
And this is the eviction suit, but my learned friend was talking about. There is a eviction suit which was made returnable on 2nd of July, and thereafter we have no notice whether this eviction suit has been withdrawn and what is the status of this eviction suit. And on the other hand, he says in this writ petition that he is going to give us, after construction, he is going to give us the space for our whatever tenancy in that particular property. And Dio Solvex is the landlord, and these are the tenancy bills. Why not? This basically is not, there is no concept of any super tenant or any tenancy on that particular property, and no consent has been obtained from us. I am actually adding to that submission made by the other private respondents. I am setting out this example that this agreement for assignment also, which actually does not entitle the owner to have any sanction plan to be presented before the corporation and get it sanctioned from the Kolkata Municipal Court. There is no locus standi of the owner.
You are also Mr. Das, right? Mr. Mitro. Mr. Mitro, tell me one thing. Forget about all this dispute. If you declare a property to be dangerous, what do you do?
Initially, I issue notice under section 411.
You have done that.
Thereafter, if the other provision of 411 and 412 is not possible, I will go for 412A to appoint a developer and to get the property developed, and thereafter giving the tenant his possession and giving possession to the landlord after recovering my cost.
In how many cases you have done that?
Not a single.
Not a single.
Let's not only see, law is not made. We are not
submission. Let this matter be referred to Director General meeting for a hearing. Let's seek all persons and a hearing and pass it.
Matter be kept. My lord, I am for the respondent number 6, my lord.
Have they made any?
The alternative under there are conciliation officer. There are various conciliation officers. If the matter will refer to any conciliation officer, all the parties to conciliate the procedure.
Only if they are willing.
That can be done, lordship. But matter be kindly be kept before your lordship.
Can you refer it to mediation?
Yes, lordship. Yes, lordship.
Let's refer it to mediation. See.
No, we are agreeable. We are agreeable. We are agreeable.
Mr. Karmakar, use your good office, sort it out. This will never end.
Lord, I shall definitely.
Off the record, the owner has number of times tried to amicably settle with the tenants. So that way it has not been settled. There has been this concept. We are trying to, my lord, but the owner is of some other views. Actually, we are actually not coming in.
How much more we will?
We are actually not coming in between.
Under the premises tenancy, this landlord has a right to get eviction under.
Yes, we have withdrawn it. We have a right. We have withdrawn it.
There is a ground for building and rebuilding.
For building and rebuilding.
After rebuilding,
He can ask for
of equal area.
Lord, in the mediation process, Lord, out
That
of
is- that is
discussion, I
section
understand, Lord,
393 read with
various
Rule 142 of the
proposals
KMC
will come
building.
which might sort out the problems.
The petitioner in the present writ petition is challenging the take down the petition in the present writ petition is challenging the inaction of the respondent municipality in not sanctioning the building plan qua premises number what this is 65 Bentic
65 Benting Street.
qua premises number 65 Bentic Street, ward number 46, borough number 11, sorry 6, borough number 6, Calcutta. Full stop. It is the case of the petitioner that he is the lawful owner of the premises referred above. Full stop. He further states that it is a dilapidated building, comma, over 100 years old, comma, and the corporation has already initiated action under section 411 of the Calcutta Municipal issued notice under section 411 of the Calcutta Municipal Corporation Act 1980, right? 1980. Full stop. It is learned counsel for the petitioner states that the said building is dangerous and dilapidated and dangerous and unfit for habitation and has also put on record the certificate of structural stability structural engineer certificate dated 28/10/2024. Full stop. He further states that there is a super tenant, comma, Mr. Saeed Izaz Hussain, under whom there are 6 other tenants. Full stop. He states that the superintendent has already given his no objection for construction of the for the development of the reconstruction of the building. Full stop. The other co-tenants, full stop, learned counsel for the other private respondents dispute the said fact and state that they have not granted any no objection certificate and they are not tenants of Saeed Izaz Hussain and are having their own independent right in the said building. That's right. Full stop. At this stage, learned counsel for the parties have agreed to refer this matter for mediation to find an amicable settlement of the issues raised by both the parties. Full stop. In view of the said statement, let this matter be referred. What is the system here?
There is a mediation center of this
Let
Calcutta High Court. There
this
is a
matter be
council
referred to
office.
the
Can
Calcutta
be
High
referred
Court
over there.
Mediation Center. Full stop. See what senior mediator? What is it?
There is a
We have a panel.
there are panel of mediators are there.
Official mediators are
allotted
there,
from-
my lord. Official mediators are there.
Official mediator.
Senior official mediator shall be appointed. Let this matter. And should I fix a date? What is the
Yes,
system?
my lord, can make it a time bound. What is the matter? Maybe.
No, actually, it takes some time.
Yes, yes.
This is going to take some time. Lord,
Well, it
5
can
to 6
be.
weeks will be
the
sufficient.
office of the mediation, my lord, mediation office will send back with a report. So, my lord, makes it time bound for
They
my
will
lord.
fix a date.
Let,
Not they will fix a date.
Well, the usual practice is they will fix up a date and they will send notice to the parties. All the
Yes.
parties come, and thereafter the parties will participate. And if something's come out, if some reconciliation comes out, and mediation give a report and send it before the honorable court.
When your lordship is directing the parties to appear there, question of issuing the notice.
This is not the process.
No, my lord, that is the process.
Noti
This is a special law.
that
This
is
not
go. It
Let
goes.
this matter be referred to the mediation cell.
Yes, madam.
It is requested at a.
There is a specific.
Mediation council, after sending report, matter will be taken.
Yes, madam.
But there is no process of filing.
What did you say, Mr.
ঠিক আছে, না, না, report আসবে।
Of mediation proceeding.
Let the report be come.
Yes, yes.
Takes up generally 60
The-
days.
Let this matter be listed before this court after a period of 12 weeks.
Grateful.
Grateful, your lordship.
After 12 weeks,
And my lord, report be filed before your lordship.
No, report the office will send. My lord,
But
those-
what
Obviously,
office will
that is
send?
the
office will
usual
send.
practice.
Once
No, no, no,
a matter is referred to mediation, whether allowed,
Yes,
decided,
Yes,
not
yes.
decided.
That is
report
what I
will
was.
that's the standard practice. Grateful, my lord.
The standard practice. ma'am.
come. I'm not keeping. You take it back.
We have circular with us.
If this is failed, then you file your counter affidavit in opposition.
Obliged, my lord.
After 12 weeks, what is the date? Hey, Gopal, क्या date? After vacation, no? So which? 6th November.
6 November. Please.
6th November.
Deeply obliged.
Lordship, item number 25, kindly not today.
Not today. All right. Rest of the matters tomorrow. Mr. Banerjee, anything?
25.
Not today, he's asking.
Very